Okay.
I'm fine, thank you. I have some water. Water's okay.
Good morning. Good afternoon, rather.
Yes.
Should I sit here?
Yes.
Miss Waterhouse is not on video, she's on the telephone.
No, yes, I'm teleconference.
Hello, Miss Waterhouse.
Hello, good morning or good afternoon.
Good morning to you.
Thank you.
We're here for a detailed cost assessment hearing in the matter of CFI 048/2019 before Deputy Registrar Nour Hineidi. The claimant is litigant in person, represented by Anna Waterhouse. The defendant is a litigant in person, represented by James Leake.
Mr. Lake, would you like to start us off?
Yes, thank you.
I'm terribly sorry to interrupt, but I just have a procedural query, if I may. It goes to the order of play today, that is to say who speaks first and then responds and so forth, which I think is important to clarify before we start. So if you'll forgive me just for a minute. I'd like to say that ahead of this hearing, the court kindly clarified that it's the party making the application for the cost assessment who has the last word. That is to say, they start, the other party responds, and then the first party has the last word. I will say that I'm the claimant or appellant in this matter, and I'd like to support, and therefore should be able to start with my submissions and then respond subsequently to the DFSA's submissions. In this regard, I would like to take the court to 3 documents which are to be found within the DFSA's bundle.
To interrupt you, I will guide you as to the proceedings today. Given that the DFSA has filed a notice of commencement of assessment, and essentially that makes them the applicant in the application or in the detailed assessment proceedings, they will start and you will respond.
Thank you for the clarification. May I just, however, for the record, take the document take the court to three documents, which I will say creates an ambiguity in this regard. The first document is to be found within the DFSA bundle at pages 23 to 24, being the Notice of Commencement of Assessment of the Bill of Costs, or P4001.
Bear with me, please, while I look it up. Ms. Waterhouse, what pages were you referring to, 23 and 24?
23 and 24 of the DFSA bundle, that's right. And do you have the document?
It's just loading. Bear with me, please.
Sure.
Thank you.
Thank you. And within that document, I refer to the second box on B23 under the heading of party filing, where it reflects that the claimant's name is myself and that the defendant's name is the DFSA. The second document, please, is at page B1 to B20 of the CFSA's bundle.
B1.
That's right.
Yes, thank you.
Thank you. And in that regard, I refer simply to the first section of the first page to be found on B1, which reflects that I'm the appellant and the DFSA are the respondent. And
Right.
Finally, in this regard, I'd like to take you, if I may, to, again, within the DFSA's bundle, document A1, which is the DFSA's bundle index.
Thank you.
So on page A1, I refer to, again, the header, where the document prepared by the DFSA reflects that I am in this case, they say, to proposed appellant, and that the DFSA are the respondents. So I say it is at very least ambiguous, and that the documents point to, on the face of them, to me being the appellant in this matter. And I think that the confusion may arise from the rules within the DIFC court with regard to who needs to trigger the detailed cost assessment, which I think is why there may be some confusion over this, because those rules say that it's the receiving party, in this context the DFSA, that must file the document. But I say that doesn't mean that they are the appellant, or that they should be able to address the court first and have the last word.
Right. Waterhouse. I've done many of these cost assessments. And the person filing the notice of commencement of assessment is the applicant, or is the person seeking their costs, essentially the claimant in the cost assessment proceedings. I totally agree that you are the appellant or the claimant in the CFI 48 2019 case in the substantive proceedings, but the person who filed, or the party who filed the cost assessment proceedings, is the DFSA. For this reason, they are the applicant and they will start off with their submissions because that is the way that procedural hearings run. The person who initially filed or is making the claim gets to put their submissions in first, and then you will provide your submissions in response. So what I will say is this: I've read your points of dispute and I've read the DFSA's reply to your points of dispute, and you took me to that document a few moments ago. And I've noticed on both sides, really the issues at hand weren't quite raised. And the issues at hand are that there were costs orders made by Justice Sir Jeremy Cook. And that means that the DFSA is entitled to its costs. What I need to be satisfied of today is that the costs claimed by the DFSA are proportionate. And so really it's a question of quantum. I'm not interested in whether the cost order should have been made in the first place because that's a matter that's already been decided. So my task, and I emphasize this, my task is to identify the quantum to be paid out to the DFSA on the back of the various cost orders made by Justice Cook. So in deciding quantum, I will take you to a couple of things that we need to bear in mind. If I can guide you, please, to RDC 38, and I'll give you some time to open that up.
That might be an issue because I'm using my computer for the call.
That's fine. I can read it out to you if that would be helpful.
Thank you. That will be faster, I believe.
So Justice Cook ordered, and I'll let Mr. Lake walk me through those submissions, but in one of the orders that he made, he referred to costs being awarded on the standard basis, subject to a detailed assessment if not agreed. So that now sets the standard or the threshold for the cost assessments, in that costs will be assessed on the standard basis and not the indemnity basis unless Mr. Lake has other submissions to make in that regard. That means that RDC 38.18 is the relevant provision for us to look at, and that says that where the amount of costs is to be assessed on the standard basis, the court will only allow costs which are proportionate to the matters in issue, and resolve any doubt which it may have as to whether costs were reasonably incurred or reasonable and proportionate in amount in favour of the paying party. So that's the test that I need to apply. I will hear from Mr. Lake on behalf of the DFSA, and then I'll take your submissions in response into account. Practically speaking, we don't break each and every item down to say whether that narrative in the timesheets, for example, was a narrative or time or costs which have been proportionate or reasonably incurred. What we do is we group the various narratives into categories, and I will then in respect of those categories, and this is typically how a notice of commencement is filed, you would break down the categories and you'd make submissions in respect of that category. Ms. Waterhouse will then, Mr. Lake, have the chance to respond, and then you can take me back in case you've got any submissions in reply. You can make those submissions. I don't think it would be prudent or time efficient for us to go through each and every one of the narratives. Disbursements are usually dealt with also as a whole, but if Ms. Waterhouse has any concerns, and I did see that she's got concerns about certain disbursements which have been claimed by the DFSA, then we can break those down as and when. It's not common that every single item will be disputed by Ms. Waterhouse, but Ms. Waterhouse might have, like I said, general submissions to make in respect of the proportionality and reasonable incurrence of those costs. So on that basis, we'll start with you, Mr. Lake. You can guide us through. If it would be helpful to rather than make big submissions at the beginning, if it would be helpful to talk about the submissions that, or at least flesh out with Miss Waterhouse the submissions that she has an issue with, or the costs narratives that she has an issue with, and then you can talk through those, and Miss Waterhouse can respond to each and every item as and when you raise it, rather than doing it, where you speak. Exactly. Miss Waterhouse, does that sound okay to you?
That's helpful clarification. Thank you very much. I would like to say a few words in my submissions about the principle of these costs, and obviously it's a matter for the court as to whether those are taken into regard or not, or to what extent. But can I just ask one further question, and then I will make way for Mr. Lake, and that is, can I understand who's on the call, please?
Who's on the call?
Yes, please.
So in the room is Mr. Lake, myself, and my associate, the court clerk, Maitha Shehi. So there's 3 people in the room, and you on the call.
Thank you very much.
Maitha? Good. And the call is being recorded.
Thank you.
Sorry, just on that, can I ask, is there anybody else with you, Ms. Waterhouse?
There is not.
Thank you. Okay, so we make a start. Thank you very much for that clarification. I'm conscious that we've lost some time already, so I'll try to be as quick as I can, and we'll adjust according to the guidance that you've very helpfully given. And I should say at the outset that we agree entirely that the question today is not whether the order of Justice Sir Jeremy Cook should be varied or changed in any way. It was quite clearly made in terms that the appellant pay the DFSA's costs on the application for permission to appeal on a standard basis to be subject to detailed assessment by the registrar if they were not agreed. And that can be found at page B31 of the bundle. He also said that the court fees appertaining to the application, insofar as not already paid, had to also be paid by Miss Waterhouse. Now, we don't have any submissions to make in that regard, and we simply don't have any information regarding that. So we
I'm terribly sorry. I just missed the last bit of what you said, Mr. Lake. Could you repeat it, please?
Sorry, the DFSA doesn't have any submissions to make in respect of the aspect of the order concerning the court fees, which you may or may not have paid. We simply don't have any information about that, so we have no submissions on those. What I plan to cover today is an overview and a breakdown of the cost the DFSA is seeking, the relevant DRC court rules, which you've helpfully alluded to already, Mum, and certain aspects of Miss Waterhouse's conduct, which we submit are relevant to the court's assessment of the DFSA's costs. And lastly, I'll also address the court on the DFSA's costs associated with this hearing today and the detailed assessment proceedings. So in summary, the DFSA is seeking $44,616. Now that consists of $41,321 as set out in the statement of costs dated the 6th of January 2020. And I'll give you the reference for that. You can find that statement of costs in the bundle at page B21. And they're the costs in relation to the application for permission to appeal at that time. There have since been further costs in the amount of $3,295, and we submit that under Rule 40.44, the DFSA is entitled to its costs of dealing with the detailed assessment proceedings, and that figure comprises $847 in counsel's fees and $2,448 representing 16 hours preparing for these proceedings. So we initially sent our statement of costs to Ms Waterhouse on the 6th of January, and on the 8th of January, Ms Waterhouse responded that they are not agreed and will serve points of dispute at the appropriate time. And Deputy Registrar, you've helpfully indicated that you've already read and digested those points of dispute, and they are in the bundle at pages B1 to B20. When filing her points of dispute, Ms Waterhouse also provided a copy of her statement of fitness for work, dated the 9th of December 2019, and a letter from Dr. Victoria Fraser of Regal Chambers Surgery, dated the 27th of December 2019, and they are also in the bundle at pages 210 and 211. Those documents concern Ms Waterhouse's fitness to attend for the hearing on the 10th of December. The statement of fitness for work was taken into consideration by the judge at the time, but the letter from Dr. Fraser, the 27th of December, obviously was not, having been produced after that hearing and after Justice Cook made the order that he did. The points of dispute we submit present no reason why the order made by the judge that Ms Waterhouse should pay the DFSA's costs should be varied or overturned in any way, and we submit that there would not, respectfully submit that there wouldn't be any power of following this hearing for the court to do so now. So I'll now move on, if I may, to a more detailed breakdown of the DFSA's costs and the specific items under that. So as set out at B21, which is the statement of costs, the DFSA was seeking $31,500 in expenses and disbursements. That figure, the lion's share of that figure comprising council's fees.
31,500?
31,500, and I will go through that in a bit more detail. The statement of costs also included a figure of $5,130 in travel costs. You see that on page B22, and 4,691 DFSA staff costs at the time. That was as at 6th of January 2020.
What are staff costs, Mr. Lake?
So these represent the hours, costs of DFSA staff time spent preparing this matter, the application for permission to appeal, dealing with that.
Does the DFSA typically break down people's time into hourly rates, for example? Like, for example, similar to how a law firm would operate. Is that something that the DFSA does internally?
Yes, these figures are they're produced by the DFSA's finance team, and they're based upon an average hourly figure representing the staff cost per hour for staff of that particular grade. So you'll see, for me, the hourly rate is calculated as $153, and for Ms. Mohiuddin, the paralegal, her hourly rate is calculated at $35 an hour, and that's based on an average of the total cost of that employee's remuneration and benefits broken down to an hourly rate.
Okay.
Over the course of the year.
Okay.
So in respect of council's costs, I'll deal with those first. These consist of fees for two counsel, Mr. Andrew George QC and Tom Cleaver, both of Blackstone Chambers. Now, I should make clear that Mr. George became a DIFC court registered practitioner under Part 2 on Sunday the 8th of December last year, specifically for the purposes of the hearing on the 10th of December, and he remains a Part 2 registered practitioner. Mr. Cleaver is not. For Mr. George's fees amount to £15,655, which is $20,508.
Sorry, what was that figure again? 15,000?
In pounds, it's 15,655. And that figure is made up of the highlighted entries you'll see at pages 25 to 27 of the bundle. So all of those that are highlighted from the 17th of August 2019 through to the 12th of December 2019, the total of those figures added up is £15,655, which equates to $20,508. That's using an exchange rate at the time of £1 to $1.31. So Mr. George's work on this matter started on the 17th of August. This is and copies of the relevant correspondence regarding that are included in the bundle, and continued through to the 12th of December 2019. The hourly rate at which Mr. George's fees are calculated is £425, and I'll come on to that in a bit more detail in a moment. But you can see at pages 25 to 27 the work billed by Mr. George corresponds to significant events in the lead up to the hearing on the 10th of December. For example, following the filing of the applicants of the appellant notice on the 26th of August 2019, there's an entry of work by Mr. George on the 27th, 28th and 29th of August.
Sorry, Mr. Legg, I'm just going to... Miss Waterhouse, are you still there?
Yes, I am. Thank you.
Okay, I was just checking to make sure you're still on the line. Thank you.
Thank
Sorry,
you.
Mr. Legg.
No, that's fine, thank you. There's further work undertaken by Mr. George in early October. That was in relation to the DFSA's response to the application for permission to appeal. There was further work undertaken in early November. That was following the filing of documents that Miss Waterhouse wanted to be considered in relation to her application for permission to appeal, and I'll address you in more detail on that in a little while. And then you can see there's a breakdown of a brief fee of £10,000 for the preparation and the work leading up to the hearing that was arranged for the 10th of December.
This is still Mr. George? Or
This is still Mr. George.
Yeah.
Correct.
And does that 10,000 is that part of the 15,655?
Yes, it is. Yes,
Okay.
it is. That's right. Yeah. So 15,655 includes that 10,000 brief fee and all the work leading up to that point from the 17th of August 2019.
Thank you.
Then Mr. George also undertook further work, a very limited amount of further work since the filing of points of dispute in relation to these proceedings. And there's a breakdown of Mr. George's fees in that regard on the document at page 235 of the bundle. And that equates to a further £675 or $847. And that's in part of the additional amount that we'll be seeking in relation to the cost of these proceedings.
Yeah.
So turning now to Mr. Cleaver's fees, these are also set out in the fee notes in the bundle at pages 28 to 29, and they total £8,410, or applying the same exchange rate of $1.31 to a pound, at $11,017. That's based on an hourly rate for Mr. Cleaver of £125, and again, his fee notes demonstrate that work began in mid-August, the 19th of August, and continued through to the 10th of December 2019.
When was Mr. Cleaver called?
When was he called?
Yes.
I think it was 2008.
Okay.
I can double check that, but I think it was about 2008. And Mr. George was called in.
He's a silk though, Mr. George.
He's a silk. He's been a
fine.
silk since 2015. I think
Okay.
he was called in 1997, around about that. Yes, I think it was 1997. Mr. Cleaver, I think it was 2008.
I just wanted to assess the degree of seniority.
Yes, thank you. So Mr. Cleaver's fees amount to $11,017, and the total of council's fees are $31,525. Well, rounded down to $31,500. That's the figure that is in the statement of costs.
Okay.
The DFSA is also seeking its travel costs in relation to this hearing. These amount to $5,130, and that represents the airfare of 18,845 dirhams, and applying an exchange rate of 3.673. And that was for the flight to London on the 9th of December, for the hearing on the 10th of December, and returning on the 11th of December. And we submit that was entirely necessary for the DFSA representative, me, to attend the hearing in London in person, given the significance of the matter and the practical difficulties of giving instructions remotely to Mr. George and Mr. Cleaver.
Before we continue, Mr. Lake, would you mind if, and you can guide me on this, if Ms. Waterhouse was to respond to your submissions about council's fees, and perhaps to suggest to us what proportion of that amount she disagrees with and why, if that's the case at all? Or would you like to, did you have further submissions to make in respect of council's fees before?
Only on the hourly rates, actually. I'll deal with that now, actually, if I may, and maybe, and then and cover the other points.
And that way we can just deal with them.
Yeah, I think that's a very sensible approach. Thank you. So the hourly rates I've mentioned for Mr. George are £425 and Mr. Cleaver are £125. And we submit it's relevant for the court to take into consideration the Registrar's Direction number 1 of 2017 on indicative hourly legal charges when considering the fees claimed by the DFSA in respect of its council's expenses. And now the Registrar's Direction is the most recent one we can find. That was dated the 1st of March 2017, so it's somewhat outdated, but we still nevertheless submit that the hourly rates in that are relevant to the court's assessment. And that registrar's direction, those figures are based on a survey of law firms and is intended to provide a benchmark to the courts of the average hourly rates in Dubai according to levels of experience and seniority. There isn't a copy in the bundle, but it's available on the DRC Courts website.
Yes.
And it provides that the average hourly rate for trainees up to 5 years is $479. For lawyers of 6 to 10 years, it's $595. For lawyers over 10 years, it's $666, and for partners, it's $767. And the registrar's direction states that these should be taken into consideration when considering the rates likely to be acceptable to the court when assessing cost. Now, as I mentioned, Mr. George's hourly rate is £425, and that equates to $557. Mr. Cleaver's in dollars is $164, mine is $153, and our paralegal, Ms. Moyden's, is $35. So of those rates, the only one which comes anywhere close to being within those brackets is that of Mr. George. And his hourly rate is less than the average hourly rate for a lawyer of 6 to 10 years experience. As I said, he's a QC, in fact, with over 20 years experience. So we would submit that these rates are entirely reasonable, entirely proportionate, and this is highly relevant when considering the reasonableness of the amounts sought by the DFSA in that regard, and on no view can they be said to be unreasonable or disproportionate. So perhaps I'll pause now and allow Ms. Waterhouse the opportunity to address you on counsel's fees.
That would be excellent. Thank you very much. Ms. Waterhouse, Mr. Lake has indicated that the total amount that the DFSA is claiming for counsel is $31,500. Is that correct, Mr. Lake?
Plus an additional, an additional $847 in relation to counsel's fees in respect to these assessment proceedings.
Oh, okay. Plus 847?
Yes, that's correct.
Okay. Perhaps if we put those aside for the minute, because we can deal with those as a separate standalone category. So 31,500 is what the DFSA is claiming for counsel fees. Did you have any submissions in that regard, or do you accept that whole amount? And if you don't, what amount do you not accept and why?
Thank you. Forgive, you'll have to give me a little time because I prepared to make all of my submissions at once, but I'll do my best, so bear with me. In my submission, the court is bound in considering these matters by the overriding objective, which is to be found at 1.6 of the DIFC court rules. I will read a few lines from that to assist the court. It is there stated that these rules have the overriding objective of enabling the court to deal with cases justly. Dealing with a case justly includes, so far as is practicable, in subsection 1, ensuring that the parties are on an equal footing, and at subsection 3C, with regard to the financial position of each party. In my submission, and this is a broader submission and a submission in principle, the DFSA, with all of their resource, facing an application from a litigant in person, did not need to be so heavy-handed in their approach with regard to legal representation. And by that I mean that they did not need leading counsel and junior counsel, and indeed in-person attendance of Mr. Lake of the DFSA. And I'll make some submissions, if I may, with regard to Mr. Lake's attendance on the 10th of December at a later stage. Going, if I may, to various points regarding council's costs, I think we need to go to B11 within the DFSA's bundle, please.
Yeah, just bear with me, please. Yes, thank you.
Thank you. But first point I'd like to make is that the DFSA's response, and I'm talking about this document that we're looking at, doesn't deal with point of principle point 2, subsection 3, which was my point that an oral hearing on the merits of the permission application did not take place, leaving counsel free to perform other work. There was a brief hearing of 45 minutes, but after that the parties were released, as I understand it. As you know, I was not able to attend due to my ill health. Also dealing with point 2, point of principle, I will say that junior counsel, and I refer to Mr. Cleaver, junior counsel was involved with each step of the proceedings and must have been familiar with the full history. To the extent that this court finds that the DFSA are entitled to counsel's costs, then the cost should exclude leading counsel's fee, and junior counsel's fee should be significantly reduced to reflect the fact that the application was not heavy enough to justify senior counsel at all. Prior to the hearing on the 10th of December, which I did not attend through no fault of my own, the DFSA had in fact submitted that a hearing wasn't necessary, and that ought to be taken into regard, because it's somewhat inconsistent to in my respectful submission, for them to suggest that no hearing was necessary, then to start it up with senior counsel, junior counsel, and a DFSA legal officer, particularly when they knew that I could not attend. I will say that more generally, like any plaintiff, the DFSA had a duty to mitigate cost and to ensure that costs were proportionate. And I say that those costs were completely disproportionate to the job at hand on the 10th of December. With respect to point 3, which is at B13 of the DFSA bundle,
Yes.
Thank you. I would say that whereas the DFSA have asserted that the brief fee represents a rolled-up fee incorporating both preparation and attendance at the first day of a hearing, to me the fee notes of counsel suggests otherwise, and I'd like to take you to B25 onwards in the DFSA's bundle, if I may.
Yes, Miss Waterhouse.
Thank you. So at B25, there are some highlighted line items within Council's bill, and I can see that, well, we can all see hopefully that there are a number of those: 17th of August 2019, 27th August 2019, 28th, 29th, and so on. We see further items that appear to relate to the application for permission appeal for appeal on the 5th of October and the 10th of October. And my short point is that whereas the DFSA have said that there was a one-off rolled-up brief fee, this invoice, on the face of it, appears to indicate that there was a brief fee and various lines of various items of billable work to council on various dates in the run-up to the hearing on the 10th of December. In my respectful submission, both can't be true.
So you're saying that there was a double count?
It appears that way. That's my concern. So to the extent that the DFSA have argued, and I'm referring to their response at point 3 within the points of dispute, the DFSA say there, don't they, that the brief fee represents a rolled-up fee incorporating both preparation and attendance at the first day of the hearing, whereas the document, the invoice, from Blackstone Chambers appears to indicate on its face that that's not wholly correct, because in addition to the brief fees that are set out within that index for attendance for both the QC and junior, there are also additional cost items set out for various bits of work connected with preparation for the appeal. So it's either the case that the brief fee included all preparation and attendance, as the DFSA states in their response, or it's not. There appears to me to be a discrepancy in those positions.
Mr. Lake.
Yes, certainly. Thank you for the opportunity to respond.
I'm terribly sorry. I had a couple more points on council's costs.
Of course.
Should I make them now, or?
Yeah, perhaps make them now, and then Mr. Lake can just respond to everything in total. I apologise.
I thought that might be the easiest. So yeah, bear with me. A couple more points to go. Further, with respect to council's costs, I will say that the DFSA have adduced no evidence to demonstrate what was agreed in advance of the work taking place. Within their response, they state that the fees of council were agreed in advance of the work taking place. Such evidence in my submission could have included something like the engagement letter or instruction to council. However, I don't see any evidence of what was agreed between council and the DFSA with respect to the relevant costs. And I think we established at the start of this hearing that the onus is on the DFSA to satisfy this court that the costs it has claimed are reasonable and proportionate. Noting your helpful guidance with respect to RDC 38.1. In this regard, I would say that it would be unsafe for the court to determine whether those fees were reasonable or not without knowing what was agreed in terms of the arrangements between council and the DFSA. In that regard, whilst barristers are free to agree various different types of cost charging with their clients, we don't know, in fact, what was agreed, and we haven't seen any evidence of what was agreed. And that, I will say, goes also to issues that hopefully I will address later on. For example, whether there was any facility for the DFSA, bearing in mind their long-standing commercial relationship with Blackstone Chambers, to seek to mitigate their loss for the hearing that was over after 45 minutes, we're told. For example, I would like to put that the DFSA could have asked council, could those wasted fees, if you will, be applied to another matter in the future. I will also submit that a total of £15,000, and I'm referring to the costs of Mr. Cleaver and Mr. Mr. George, excuse me, for a 45-minute hearing is extraordinary and exorbitant. That's an hourly rate, £20,000 an hour, or roughly 100,000 dirhams. The DFSA did not take any steps, so far as I'm aware, to ask for a reduction in fees, and that goes to my point earlier. Given, and I think that they could have asked for a reduction in fees on the basis that it did not in fact proceed to a full hearing, and counsel were released to perform other billable work after 45 minutes. I would say that the DFSA took no steps to mitigate their losses. I will also say, but I bear in mind some comments made by Mr. Lake earlier on, to the extent that he says that the costs were in line with average rates for council. I believe he should have included that information in the bundle if he was going to rely on it. But in this regard, I would say that prior to the statements made by Mr. Lake this morning, the DFSA had adduced no evidence as to whether the legal costs were in line with average rates for council. And I say that by analogy, page and this document is at page 35 of my bundle. I will say that the IFC Court Rule 23.98 applies in this context by analogy. Now, that rule appears to relate to instant costs award. However, I'd say that by analogy it does apply. Excuse me. And further that the DFSA have not adduced any evidence to show that the rates charged by Blackstone Chambers were in line with the average hourly expense rate for legal representatives in the DIFC or Dubai.
Ms. Waterhouse, what are you contesting from the 31,500?
All of it, because I say the hearing should not have proceeded. You have already set out some guidance in that regard, and hopefully the court will indulge me by hearing some submissions that I've prepared in that regard. But notwithstanding that, I say that the fees were excessive, and what I said in my points of response was that QC's fees should be disallowed because they didn't need a silk in those proceedings, and that the fees of the juniors should be substantially reduced.
I've just got a couple of questions before I hear from Mr. Lake. I do recall that the hearing was obviously set down. Mr. Lake then travelled over to the UK. The hearing was then vacated and the matter determined on the papers. So what was the original time allocated to the hearing? Mr. Lake?
Yes, I'm happy to address it.
Thank you.
On that. Ms. Waterhouse originally requested a hearing for 2 days.
2 days, okay.
In fact, it was set aside for 1 day.
Okay.
On that date, the hearing was confirmed on the 26th of November 2019.
Thank you.
I'm sorry to interrupt. I don't mean to disturb you, but I have a couple more points with regard to council's fee, if I may, just to finish that portion of submissions.
Sure. Go ahead, please.
Thank you. Also on council's fees, within the DFSA's response to my points of dispute at point 5, I would like to say that the DFSA have produced no evidence to support their assertion within point 5 that the fees are reasonable and consistent with fees charged by counsel of similar relevant expertise and experience. That's at B15 in the DFSA's bundle. I say that there's simply no evidence before this court to support that assertion. With respect to point 6, of the DFSA's response, again within their bundle. At point 6, my submission is that the brief fee is only one method of calculating a barrister's fee. A barrister can also charge by the hour, and as the DFSA have not produced the instructions that they gave to counsel or evidenced the terms of the engagement, they've not supported their explanation with any evidence. In my respectful submission, and with respect to, sorry, forgive me, with respect to point 7, again within the DFSA's response, the material at B25 to B27 of the DFSA's bundle appears to indicate, and I covered this point before, that the DFSA claiming for the preparation by counsel and for the brief fees, and so far as I'm aware, there's no other breakdown of costs. With regard to point 8, I will say that it's not correct for the DFSA to say that no substantive hearing, the fact that no substantive hearing took place is entirely and singularly a result of the appellant's actions and circumstances. And I will say that that submission is clearly inappropriate and unfair in circumstances where there was uncontroverted medical evidence that I was unfit to attend the hearing. With respect to point 9 of the DFSA's response, I will say that it's quite simply irrelevant in this context that I've been represented by counsel at previous hearings. The DFSA were well aware that I was a litigant in person at the commission hearing, and my commission application filed with the court was filed on that basis. In my respectful submission, the DFSA should not have instructed a barrister who did not have rights of audience in DIFC courts. That's a reference to the DFSA's response seeking to justify why Mr. Cleaver couldn't have made the application without this. So it seems to me somewhat bizarre that the DFSA would instruct a barrister in a matter who doesn't have rights of audience. I can't understand that.
To interject to Mr. Lake. Mr. Lake, are you claiming back the registration fee?
No.
Okay. So I think that's quite clear. Mr. Lake, or the DFSA, is not claiming back the Part 2 registration fee for Mr. George. So I think perhaps a submission was made in passing. Was there a relevance to that submission, Mr. Lake?
Only on the basis that it was it's in the context of enabling the DFSA to participate fully and be properly represented in the hearing before Justice Sir Jeremy Cook.
Okay.
We needed to ensure that we had the appropriate counsel to represent us in that hearing, and not just somebody who happened to be a Part 2 registered practitioner and would have rights of audience before the court. There's a lot more to the history of this case that justified the attendance of Mr. George and Mr. Cleaver.
Okay. Thank you very much.
If I may, I'll have a query for Mr. Lake in that regard, because it's news to me today that, as I understand it, Mr. Lake said that Mr. George QC had to get that Part 2 qualification in order to have rights of audience. If that's the case, how did he represent the DFSA at a number of hearings in the same case if he didn't have that registration? Forgive me, I don't understand how it was then that he conducted the hearing the hearing in April of 2019, I think it was, and or 2018, forgive me, and then the hearing in London thereafter. Could you explain that?
Yes, Ms. Waterhouse, it's very simple. The proceedings before the FMT are subject to its own rules of procedure. The proceedings in the DIFC courts are subject to its own rules of procedure, and it's a requirement of the DIFC courts for people appearing before it to be registered practitioners. There is no equivalent requirement in relation to proceedings before the Financial Markets Tribunal. Does that answer your question?
It does, thank you.
Ms. Waterhouse, have you concluded your submissions on council's fees?
I believe so, yes.
Thank you, Ms. Waterhouse. Mr. Lake.
Yes, thank you. If I may go back to the first point that Ms. Waterhouse made regarding what you referred to as the rolled up fee.
Yes.
And the relevant passages of the points of dispute, B11 and B13. And the point on B11 is that Ms. Waterhouse makes an oral hearing on the merits did not take place, leaving council free to perform other work. Now, of course, that's right. The hearing lasted about 45 minutes, but we did not know that it would only take 45 minutes. Up until the actual hearing started, which was ordered to go ahead, it was assumed that the hearing was go ahead, and Ms. Waterhouse may have appeared, and she may have appeared with counsel. But importantly, the time had to be set aside. So, Ms. Waterhouse, you've had your opportunity. If I may just respond briefly to your points, then the Registrar may give you an opportunity to reply afterwards, but I'd just like to finish this point, if I may. So the brief fee was agreed in advance of that hearing. It was agreed after the hearing had been decided. Now, and there's the relevant correspondence in the bundle, but the hearing was only decided that it would go ahead on the 26th of November 2019, and you will see in the fee note for Mr. George at page 27 that all of the work after that date, the date on which the hearing was decided would go ahead, is rolled up into a brief fee. Work on the 5th of December, 6th of December, 8th of December, and the 10th of December, attending directions hearing. That £10,000 represents that preparation over those 3 days and attending the hearing, which may have been a substantive hearing that Miss Waterhouse originally requested would be given 2 days in the court's diary. All the work before that was billed on an hourly basis. So the entries on the 26th of November and working backwards to the middle of August was billed on an hourly basis.
So, Mr. Lake, just a quick question here. If the hearing was to carry on for a further day, would Mr. George have charged you a further fee for his attendance on the second day?
There may have been a refresher fee, but as it turned out, the hearing was only set down for 1 day.
Okay.
Ms. Waterhouse requested 2 days,
yes.
Which is relevant to the DVSA's, the reasonableness of its instruction of leading and junior counsel. And I'll come on to address you in more detail on that in a little while. But if the hearing had gone on to a second day, we would have known in advance that it was listed for 2 days, and there would have been an agreed refresher fee that Mr. George would have charged for any attendance on that second day.
Okay, but the rolled up fee would have included some provision for example, written closing submissions, had the judge required such submissions, for example?
Yes, that's right.
Yeah.
Yes, it would.
Okay,
Yes.
all right, that makes sense.
Yeah.
So it's essentially finding the case or taking your victim as you find them in a way, or taking the case as you find it, where, if it was to run for, like this is the case, if it was to run for X amount of days, and if this was the amount of work or this was the amount of work, and I'm signalling with my hands, Ms. Waterhouse, but I'm trying to understand how the rolled up fee works. But in my mind, and what I'm understanding at the moment, is that the fee encapsulates a retainer, essentially, on all work carried out in CFI 048/2019 and the DFSA's defence of your permission application. So whether the work was had broadened at some stage due to, for example, the request for further information from Justice Cook, or whether the work was rather, and what ended up happening, whether the work was rather confined on Justice Cook's instructions, which ended up being the case, the fee would have remained the same either way. And that's what I'm understanding from Mr. Lake. Sorry, Mr. Lake, please.
No, that's correct. So the time would have had to have been set aside in council's diary, and the amount of preparation for that hearing would have been no different.
Okay.
Still required a very considerable amount of preparation from the 5th of December, which is the point at which you received the hard copy documents from Ms Waterhouse, which I'll mention briefly in a moment as well, leading up to the hearing on the 10th of December, which we had to assume was always going to go ahead and was going to be a substantive hearing on the merits of Ms Waterhouse's application for permission to appeal. Ms Waterhouse also made the point that there is no evidence of council's fees. Of course, well, the evidence is the fee notes. It's clearly set out there. I don't think we could be any more transparent. Any instructions that were sent to council would be privileged, and I could not imagine these would, in any jurisdiction, be required to be disclosed to make that point to the court.
But the fee note was provided.
The fee notes have been provided, and they have been disclosed to Ms Waterhouse. They're in the bundle.
Various invoices and the highlighted. Yeah.
As for the what would be the most useful indicator or benchmark of whether the fees were reasonable, as I say, we would refer to the registrar's direction. It's correct. It's not in the bundle. It's part of the court rules. It's publicly available, and we wouldn't rely on it as evidence as such. It's simply an indication of the guidance of the court when assessing costs. But the reason why it was included is because of the page in Ms Waterhouse's bundle that she referred to, I think at page 35, regarding the immediate assessment of costs in Rule 23 regarding the immediate assessment of costs, and which in that it states Rule 2398 in carrying out an immediate assessment of costs. And Ms Waterhouse made the point that she submits this is also relevant to the assessment, a detailed assessment that the court must have regard to other matters. Any survey published showing the average hourly expense rate for legal representatives in the DIFC or Dubai. Ms Waterhouse submits that's relevant. We also agree that's relevant, and that document can be seen in the form of the Registrar's Direction number 1 of 2017. As I mentioned previously, Mr George's hourly rate is less than that, which is considered reasonable for a lawyer of 6 years. So we would submit it's very reasonable indeed in the circumstances.
Thank you, Mr. Lake.
That's it on Ms Waterhouse's points. Yeah.
Thank you very much.
So I think, sorry.
Sorry, please continue.
I was now going to turn to the question of DFSA travel costs.
I was going to deal with this.
I'm sorry to interrupt. I do apologise. Can I just ask a question, please, of the Deputy Registrar? Am I able to respond with regard to council's costs to the submissions just made by Mr Lake? Because I have more to say on that, if I may.
Sure, go ahead.
Thank you. I thank Mr Lake for his submissions on council's costs. However, I would like to respectfully reiterate that he has not addressed the question of evidence with regard to what was actually agreed between council and the DFSA. We only have Mr Lake's word for the explanation that he's provided to the court today of what those arrangements actually were. The DFSA have produced no evidence to demonstrate whether that is correct or not. So it would be unsafe for the court, in my respectful submission, to conclude that those arrangements were as they say they were, on the basis of no evidence. The further point I would like to make at this stage is one that I would like to address in more detail later, and that is the facts of the situation leading up to the hearing on the 10th of December. At the time when the hearing went ahead but concluded after 45 minutes, the DFSA were well aware that I could not attend the hearing through no fault of my own, and that must be taken into regard, I respectfully submit, by the courts in this matter, and also with respect to doing justice to the overriding objective to the DIFC court rules, You have before you an unemployed individual, and my opponent, if you will, is a very well-resourced international financial regulator who had at their facility senior counsel and junior counsel and their own legal officer. It's hardly the case that the parties were in the same position, and to the extent that the costs are reduced, I will say that the position of the parties, as the court must have regard to, it is highly relevant.
Thank you, Ms. Waterhouse. In terms of the evidence that you've requested on what was agreed between the DFSA and Council, I think Mr. Lake did actually address that point. And his point was that that information is subject to privilege because it's subject to, or the discussion between the DFSA and their Council on what fees or what work would be undertaken is obviously subject to client solicitor privilege, so that cannot be disclosed, and it's not common. In fact, I've never seen it in the many detailed assessments that I've done. I've never seen retainers or engagement letters be disclosed to discuss the scope of the work that was completed. Now, I have heard your point on the fact that the hearing only lasted 45 minutes. And I've heard Mr. Lake's point in that the fee was a rolled up fee, and typically with such commercial arrangements, if the hearing was to go for half a day or a full day, the fee would not have changed. What I would consider, however, is the proportionality and what the DFSA ought to have done, or what a reasonable party would have done in those in such a situation where the hearing was vacated essentially and only ran for 45 minutes rather than the full 8 or 9 hours that it was scheduled to run for. So on that basis, I am considering a slight reduction of the fee claimed by the DFSA. I just wanted to go back to that figure that Mr. Lake discussed, 31,500. Now, Mr. Lake, I agree that the hourly rates are very much proportionate and they're in line with the Registrar's Direction number 1 of 2017. And when we test proportionality, it's typically the hourly rates that we look at. We don't look at whether your case was fought, to the maximum extent, because every party has the right to fight their case in whichever way they see fit. And that's not something you ought to be reprimanded for. So if we take the 31,500, the rolled up fee comprised £10,000, or was it £15,000, sorry?
The free fee was £10,000. The 15,000 was the total of Mr. George's fees for all of the work in relation.
Okay. So I think if we apply a 10% reduction to that amount.
So the figure in dollars, it was 20,508, Mr. George, in dollars.
20,508. And Mr. Cleaver attended the hearing on the same day?
That's correct.
Okay, he did not have a rolled up fee.
He did. His fee was £5,000. Yes, that's right. So,
£5,000.
And that's on page 29.
Okay, and what's that in US dollars, please?
That's sorry, the total of Mr. Cleaver's fees for all of the work leading up to that, including the attendance, is $11,017.
$11,017. So when you add the 20,508 and the 11,017, that then brings us to the figure of 31,500.
That's right. Yes.
Okay. I will apply a reduction of 10% to 31,500 on the basis that the amount could have probably been negotiated by the DFSA with council so as to say that because the hearing hasn't proceeded, can we have a slight discount on the rolled up fee? And what I think is reasonable and proportionate to the circumstances is a reduction of 10% of that fee. So that takes us down to 28,350 for that category. So I will award 28,350 for the category of council fees.
Deputy Registrar, may I make a further point for the record, just with respect to the issue of council's instruction?
Yes, go ahead.
Thank you. I've heard what has been said with respect to privilege. I would like to say that the at least the English law doctrine of privilege with respect to attorney-client privilege and litigation privilege is actually very narrow. I don't think it's going to assist the court to have submissions on that point. But I will say this: the DFSA could have dealt with the issue of evidence without, in my respectful submission, having to worry about privilege. If, for example, the DFSA, an officer or representative, such as perhaps Mr. Lake, had made a witness statement accompanied by a statement of truth, then that would at least give the parties some evidence to look at and to test, whereas what appears to be the case is that I can rely only on what the DFSA say the arrangements were, and there being no evidence of them.
I believe the DFSA, when they submitted the notice of commencement of assessment, would have signed a statement of truth when the document was submitted. So I think that answers your question, I hope.
I don't fully agree, but I've made my point, so I'll let Mr. Lake continue if that is now the order of play.
Thank you. So I think Mr. Lake was going to move across to travel costs.
Yes, that's right, thank you. But just on that, I mean, obviously the fees for council were agreed in advance with their clerks, and there is email correspondence confirming that. We don't think that's relevant. The fees are stated as stated in the fee note, and I think it would be quite inappropriate and improper to disclose that private communications with council's clerks regarding the negotiation of the fees, and I don't fully understand the point that Ms. Waterhouse is trying to make, to somehow suggest that fee is not a bona fide, genuine, agreed fee. But I only make that
I'm just saying there's no evidence of it.
Ms. Waterhouse, I should add one thing for the record, which is that if the fee was excessive, and if the DFSA had a reputation for not declaring things properly, which as a regulator that would be obviously very, it would be hugely awful conduct, then there might be a reason to then ask them to provide certain documentation. But the fee that they are claiming under this category is a very reasonable fee. They were defending an entire case against them, and a regulator ought to have a strong team, and typically, in fact, actually, if you took the DFSA out of the equation and put just a normal company in, the fee could have been much higher, based on my experience and the usual assessments that I conduct. So I think the fee, in the grand scheme of things, is a proportionate one. The matter was filed or did run for a few months, and the fee is not disproportionate in my view, or unreasonable. But I do agree with you, like I said, that the DFSA probably could have tried to negotiate something with council on the basis that the hearing did not proceed or run for the full day, and that was the basis in which I discounted 10% from the amount claimed under that category.
Thank you for that clarification. May I say one last point on council's fees, and that is, I believe that you have just said, or forgive me if I misunderstood or misheard, but I believe that you just said that the fee was proportionate relative to the DFSA's having to defend the whole matter. I would like to clarify this point, because I think it's very important that the court understands that wasn't the purpose of the hearing on the 10th of December 2019. That was an application, it should have been my application for permission to appeal, but not the defence of the whole matter as it was described. That part of the hearing had been already concluded, and presumably separately billed by council. And the purpose of the hearing on the 10th should have been for me to persuade the judge that it was appropriate to grant me permission to appeal the findings of the case that had already been determined, i.e. the case before the Financial Markets Tribunal. In that regard, the DFSA had suggested that no hearing need take place, and there is documentary evidence of that being their position. So I will say also that it's inconsistent that they would argue that no hearing needs to take place, and then in the context of knowing further that I couldn't attend the hearing, proceed with the hearing, and need to have Queen's Counsel, Junior Counsel, and Mrs. Lake.
Ms. Waterhouse, my decision's already been made in that regard, but to the extent that you require further clarification, I'm completely aware that it was a permission application that the DFSA was responding to. Usually when people plead a permission, or on the other side where they defend the permission, you put all of your cards forward, because essentially you put your best foot forward for both the permission or the defence to the permission. And I think there was one final point to make, which has completely slipped my mind. But I'm satisfied, like I said, that the fees were incurred, or the fees incurred were reasonable and proportionate in the circumstances, despite the fact that the DFSA said that no hearing was necessary. What did end up happening was the hearing was ordered, and it was set for one day. So that's the basis upon which the DFSA then presented and prepared its case, and that's the basis upon which the fees were incurred. So I trust that that now concludes all comments in that regard. We've probed this topic forward a fair few times, and I do remind the parties that it is very important to remain very efficient in these detailed cost assessment proceedings, on the basis that parties are still incurring costs as we go. So I've heard your points. I agree with a couple of your points, and I mentioned that. That's the reason I deducted the 10%. But I think now it's best that we move forward and discuss the other points, so that we can try and find an efficient outcome for everyone. Yes, Mr. Lake.
Thank you. So turning now to the question of travel costs, the DFSA is also seeking those. These amount to $5,130, and this represents the airfare of 18,845 dirhams at an exchange rate of 3.67 dirhams to the dollar, and that was for the flight to London for me on the 9th of December 2019 for the hearing arranged for the 10th, and then returning on the 11th of December 2019, as we submit that, it was entirely necessary for me to attend that hearing in London, given the significance of this matter and the difficulties of giving instructions remotely. And now to elaborate on that, if I can take you to Rule 38.23 of the DFC Court Rules, which sets out the factors the Court must have regard to, in addition to the proportionality and reasonableness of costs incurred, but it must have regard to these other factors in deciding the amount of costs.
Thank you.
And those factors there include the conduct of the parties, including the conduct before as well as during the proceedings. Secondly, the amount or value of any money or property involved. That's not really relevant here. The importance of the matter to all the parties. That's on point 3. The particular complexity of the matter or the novelty of the questions raised. The skill, effort, specialised knowledge and responsibility involved. That's the 4th point. The time spent on the case, and the place where and the circumstances in which the work or any part of it was done. Now, under each of these headings, there are a number of features of this case and the hearing on the 10th of December that demonstrate why it was reasonable and proportionate for the DFSA to instruct counsel. That issue has been dealt with, leading and junior counsel, but also for the DFSA to travel to attend that hearing in person. First, this is an important matter. There can be no doubt about that. It was the first substantive challenge to a DFSA decision. It was referred to the FMT. It was the first substantive decision of the FMT. It was the first ever appeal of a substantive decision of the FMT. And Miss Waterhouse recognises this matter as being important, and in her grounds of appeal, in paragraph 37, she stated that a full appeal with a reasoned judgment of this court on the exercise of the tribunal's case management powers, including postponements, abuse of process and bias, would assist other parties involved in the conduct of financial services in Dubai. And similarly, in her skeleton argument that was drafted with the assistance of counsel at the time, Mr. Wright, dated 15th of September, that accompanied her 17 grounds of appeal, she said that the grounds raise issues of general importance to the financial services industry and any future litigants generally in Dubai. This is a significant case. It was a very significant for the case. And involved serious allegations against the tribunal, casting doubt over its judgment, and it was therefore only right for the DFSA to treat this matter with the attention that it deserved. Secondly, this case had been going on for a very long time. DFSA decided to take action against Miss Waterhouse in June 2017. That's over 3 years ago now. Before that, there was a period of administrative proceedings lasting a year and a half, and all of this was flowing from events which began in December 2012. The DFSA's decision was referred to the FMT in July 2017, and the final decision was issued on the 12th of August 2019. As we know, Ms Waterhouse sought to appeal that decision. It was eventually disposed of in December last year. But given the length of time and importance to the DFSA, it was proportionate and entirely reasonable for the DFSA to instruct leading and junior counsel who were familiar with the case, and for the DFSA to attend and be present in person to give instructions as necessary in the hearing of the application for a commission to appeal. Thirdly, this case is not only important, but it's also novel. As I indicated, there are many firsts for the DFSA, including the substantive referral, first ever full trial before the FMT, including a subsequent appeal attempt. It was simply not practical for the DFSA to use other counsel, and it was entirely appropriate for the DFSA to ensure that it was properly represented at that hearing, including the attendance by me in person, not knowing what was going to happen that day. But fourthly, and perhaps most importantly, the reason why it's important to travel sort of relates to the issue regarding the conduct of the parties. We would submit that Ms Waterhouse's conduct alone demonstrates why it's appropriate for the full extent of the DFSA's costs, noting the reduction that you've given in relation to counsel's fees, for those to be awarded to the DFSA. I'm happy to pause now, or I was proposing to go on to identify those particular aspects of Ms Waterhouse's conduct that we submit are relevant to determining. Thank you. So as I stated, the appeal notice was filed on the 26th of August 2019, and in that she said her grounds of appeal and skeleton argument would follow in 21 days, and that's permitted in the rules. We don't take any issue with that. But for completeness, the DFSA wrote to the court on the 29th of August inviting it to dismiss Miss Waterhouse's application on the basis that she had not complied with the relevant rules. But that was overtaken by events because Miss Waterhouse did subsequently file her grounds of appeal and her skeleton argument on the 16th of September 2019. Now, I've already referred to the relevant parts in that Miss Waterhouse asserts are as important for this matter to proceed. But in that, Miss Waterhouse also requested a further 21 days in which to file her documentary evidence in support of her grounds of appeal. Miss Waterhouse said that she's been able to identify and compile the relevant documents, and these are set out in paragraphs 19 and 20 of her skeleton argument, and she sought an extra 21 days from 16th of September to file those. So that would have taken us up to the 7th of October. So Miss Waterhouse was due to file the documents she relied on the same day as the DFSA was required to respond to her application for permission to appeal. The same 21-day deadline applies to responding to her grounds of appeal in skeleton argument that applies to the extension that she was seeking. And the rules in Part 44 are quite clear on what documents must accompany the grounds of appeal. That includes certain things. This is not in dispute. So Miss Waterhouse should have filed her documentary evidence in support of her application with her grounds of appeal and skeleton argument on the 16th of September, but she did not do so, as we know, and she wanted the extension until the 7th of October. But in the event, Miss Waterhouse did not file those documents on the 7th of October. Instead, on the 7th of October, Miss Waterhouse asked for yet more time until the 28th of October to fully particularise her grounds of appeal, file an amended skeleton and provide supporting documents. She said it was not possible to do so given that she needed access to certain hard copy files and they had been put into storage by the leading counsel that represented her during the FMT proceedings. There were further exchanges with the registry over the course of early October, 7th and 9th of October, and they're all in the bundle at page 63. And Miss Waterhouse eventually filed a Part 23 application with a witness statement and a draft order in support of her request for an extension on the 18th of October 2019, by which time the DFSA had already filed its submissions in response to her application for permission to appeal. I wish to emphasise that we don't take issue with the late filing of the documents. In fact, we told Miss Waterhouse twice that we were not opposed to her application for an extension of time, but rather we raised this to highlight a pattern of behaviour by Miss Waterhouse in repeatedly asking for extension requests and not unnecessarily prolonging these proceedings. And such behaviour is a relevant factor in determining whether it was reasonable for us to attend the hearing, not knowing what was going to happen on that particular day or what issues Miss Waterhouse might raise. So the various extension requests are laid out in the bundle that's been provided. So, for example, on the 15th of October, Miss Waterhouse was told that she had to file a Part 23 application, and she was told to file that by the 17th of October. That's at page 68. So Miss Waterhouse then asked for an extension to that deadline. So in effect, what Miss Waterhouse is doing is asking for an extension, the deadline for an application, for an extension to another deadline. Now this sort of behaviour, this sort of conduct, goes only to disrupting and creating difficulties in the effective management of these proceedings. And we would say that this is an example of what Justice Sir Jeremy Cook described as Miss Waterhouse playing fast and loose with court procedure. That's in paragraph 21 of Justice Jeremy Cook's order with reasons. So although we didn't take any exception or object to Miss Waterhouse filing these documents, which were eventually filed on the 7th of November, and they were around about 670 pages, we do take issue with what was eventually filed, and this is relevant to the work the DFSA had to undertake in preparing for the hearing. So the DFSA submissions on those extra documents that were filed are set out in the revised response to the application that was updated on the 20th of November. And for your record, Deputy Registrar, that's at pages 142 to 165 in the bundle, and that outlines there the concerns that we had regarding those extra documents filed by Miss Waterhouse. Now, fortunately, the documents that she did file were very difficult to follow, and they required a significant amount of work to put them into any sort of sensible order. And if I can refer you now to page 91 of the bundle, you can see what Miss Waterhouse filed on that particular day. And this is a screen print of the court document filing sheets that Miss Waterhouse filed on the 7th of November. And there's 13 entries. The top one is for witness statement on the 3rd of November, and then there's 13 that follow, all filed on the 7th of November. And they show the various documents that Miss Waterhouse submitted on that day. So some consisted only of 2 documents. Each one has both the filing sheet and the underlying document. So when it says 2, in fact, there was only 1 document that was filed. When it says 16, there were in fact 15 documents filed, 8, 7, 14, there were 13 filed, and so on and so forth. So in total, Miss Waterhouse filed 13 separate filing sheets and 122 documents of varying size. Some were blank, some were duplicates. There was also no index, there was no discernible order to them, and there were file names didn't correspond to any numbering or had been used in the FMT proceedings previously. And they required a very significant amount of work to review and understand what had been provided, but also what had been left out from the bundle of documents that had been used and referred to in the FMT proceedings. And Miss Waterhouse had in fact provided only certain sort of select extracts from particular documents, so she had cherry-picked parts of some documents. So the DFSA produced an index of that, and that can be found at pages 120, forgive me, 118 to 120, 130, 118 to 130 is the index that the DFSA prepared to understand exactly what Miss Waterhouse had filed on the 7th of November, and prepared to assist the court in understanding what she had filed and making sense of what she had extracted selectively from the bundle that was before the FMT. We also agreed or offered to undertake the administrative burden of preparing bundles to be submitted for the hearing on the 10th of December, but Miss Waterhouse declined that offer, saying that she wanted to prepare our own, and that's set out in the correspondence on the 4th of December. That's at page 181 of the bundle. So in any event, there were a number of documents, around about 670 pages, that were filed on the 7th of November, but the bundle that was actually provided to the Judges' Chambers on the 5th of December included additional documents that hadn't been filed electronically previously. Now that is also relevant to the question of the DFSA staff costs that we are seeking as well, because of the haphazard way in which these documents were filed. We had to spend a lot of time and undertake a lot of work in understanding that, and we submit that without that the judge would have found it impossible to consider the relevance of the documents that Miss Waterhouse had submitted in support of her application, and we therefore submit it's only right that the DFSA be awarded its costs in that regard. Now I can deal with those now, those amounts, if that would help.
Yes.
But this also is relevant to the issue of why it was necessary to travel to understand or to attend the hearing in person, but to give instructions on the basis of those documents that have been provided and have been presented by Miss Waterhouse as being relevant to her.
Your hands, Mr. Blake, so...
Thank you. So actually, if I might, I think it might be appropriate now to deal with the question of the 10th of December hearing, because again that's relevant to both the travel costs and the work undertaken in relation to so for that, if I can refer you please to page 83 of the bundle, and this is rather a significant event in this particular matter. So page 83 is a copy of an email from Miss Waterhouse on the 28th of October to the Registry. Now, towards the bottom of the page, under point 4, Miss Waterhouse states there, "Consider the application for permission is best decided at an oral hearing before a judge of the court of first instance. I'll be grateful if the Registry will consider listing the application in London with a time estimate of 2 days." In fact, as we know, it was only listed for a hearing of 1 day. But it wasn't just a short hearing to deal with an ordinary application. I think Miss Waterhouse suggested earlier on that this was only a light matter. In fact, this would be treated as a heavy application under the court rules. And in fact, she wanted 2 days before a judge of the Court of First Instance and in London as well, presumably for Miss Waterhouse's convenience to attend. There then followed a series of exchanges throughout November. On the 11th of November, the registry informed the DFSA they had the right to file a revised skeleton in light of the documents that Miss Waterhouse had filed on the 7th of November, and the parties were asked to confirm their availability for the hearing on the 4th, 5th or 10th of December. And that correspondence is at page 131. Bundle. And I'll skip through these pages as quickly as I can, but it sets the scene and context for what happened on the 10th of December. So on page 131, the parties were asked to provide their availability for that hearing. The DFSA responded on the 14th of November on page 132, confirming that of the date proposed, the DFSA and its counsel are currently available to attend the hearing on the Tuesday the 10th of December. Miss Waterhouse responded on the 18th of November, suggesting the DFSA could put in written submissions but not attend the hearing, and would not be allowed to address the court. And she raised a question around the application of the CPR, the Civil Procedure Rules in the UK, suggesting the DFSA shouldn't be able to address the court at her application for permission to appeal. The DFSA responded on the 20th of November, saying that we did wish to attend and be heard at any hearing to determine her application for permission to appeal, assuming a hearing was going ahead. And it's not in dispute that we had previously said that we were happy for the matter to be dealt with on the papers, but obviously Miss Waterhouse was not. She previously indicated she wanted a two-day hearing. And the registry told Miss Waterhouse that the CPR wouldn't apply, and the court would apply its own rules. The parties were also given the opportunity to make submissions on whether the application should be dealt with on the papers of the hearing, and the court asked for those to be provided by the 21st of November. Now that's page 166 of the bundle. 166, yeah. I'm sorry this is taking a long time, but it is relevant to the events that happened on the 10th of December. So Miss Waterhouse was informed on the 20th of November that the court would apply its own rules and not the CPR, and that DFSA did have a right of response on the question of permission to appeal. And if a hearing was rendered necessary, then it would be on the 10th of December. And if the parties wish to make submissions in respect of whether the question of permission should be dealt with on the hearing, then the parties ask that the registry have those by 12 o'clock on the 21st of November. Miss Waterhouse responded yet again, perhaps unsurprisingly, that she needed more time, and she asked for extra time until the 25th of November. That's at the top of page 166. The DFSA responded on page 168. You'll see the email on the 21st of November. The DFSA was content for the application for permission to appeal to be dealt with on the papers. Ms Waterhouse filed her submissions on the 24th of November, and again with complete transparency, they are in the bundle. That was the email is at page 170, and then the submissions begin at page 172. And just spending a couple of moments on those, if you have them available.
Yes.
On your screen. So in paragraph 5.
I'm sorry, Mr. Lake. Could you help me with a page or bundle reference, please?
Page 172, Ms Waterhouse.
Thank you.
So these are Ms Waterhouse's submissions that were provided to the court on just 1 minute past midnight on the 24th of November, so very late on the 23rd of November. In paragraph 5, Ms Waterhouse was requesting an oral hearing. She said it was necessary in order that I may fully explain these grounds, those grounds being perversity and questions over adequacy of reasons given by the Financial Tribunal. Paragraph 6, Ms Waterhouse said, also consider without any sort of explanation from me as to what I say the relevance of particular documents. There's no realistic possibility that the court will be able to understand the significance of the documents filed. As I've already said, the documents that were filed were in a haphazard way and very, very difficult to follow, and were selected extracts of a very significant bundle of documents presenting the totality of evidence that the FMT considered in detail over a significant period of time. So the hearing was necessary for Ms Waterhouse to give her explanation of relevant documents which she had selectively provided. Paragraphs 9 and 10 on page 173. Ms Waterhouse said an oral hearing is in the interests of justice to do so, and that the issue of an oral hearing is to be reconsidered. It should be decided by a judge of the court of first instance who will decide the substantive application for permission to appeal. And that is exactly what happened. It was considered by Justice Sir Jeremy Cook, who was the judge dealing with that. And then lastly, Ms Waterhouse, on page 174, said it was in the interest of justice and to meet the overriding objective for the court to hold an oral hearing in respect of the application for permission to appeal. So Justice Sir Jeremy Cook decided that there should be a hearing, and that the evidence, the email confirming that is on page 175 of the bundle. That in light of the fact that no hearing took place of any application for permission before the FMT, and the history which suggests there may have been some expectation of an oral hearing, he decided that there should be a hearing of the application for permission to appeal, and that date was arranged for the 10th of December. Now, as I've mentioned previously, the 26th of November is significant to the date on which Mr George began work on brief fee for preparation and attendance at that hearing on the 10th of December. So after that exchange, so everybody was under the impression that there was to be a hearing on the 10th of December before Justice Sir Jeremy Cook at the IDRC in London. And then actually what happened on the 9th of December is also worth spending some time on as well, and that's in the relevant exchanges are in the...
This goes towards staff fees and
travel costs, exactly, yes it does, yeah, this is relevant to both issues, so I'm sorry I'm taking rather a long time on this.
No,
Page 192 of the bundle is the email from Ms Waterhouse at 2:33 in the morning, Dubai time, I should add, to the registrar, copied to me at the DFSA and our litigation email address, and the subject is of the utmost urgency and for the immediate attention of Justice Sir Jeremy Cook. And in that, Ms Waterhouse states, I wish to apply to postpone the hearing on the 10th of December, in case CFI 48, 2019, on the ground that I'm unable to attend due to ill health. I'm representing myself at the forthcoming hearing. I've been unwell for approximately 3 weeks, but as of today my symptoms have got a lot worse and I'm in considerable pain, the left side of my torso. I plan to attend my doctor's surgery today, and I'd forward my medical certificate as soon as it is available to support my application. So there was no medical certificate provided at that point, and indeed there was a very considerable number of exchanges throughout the course of the day, which ultimately led to Justice Sir Jeremy Cook deciding late in the evening on the 9th of December that the hearing would go ahead. But at the point at which this email was received, it was at 2:33 in the morning of the day on which I was due to fly over to London for that hearing. And I don't recall seeing that email at that time, it was 2:30, but I do recall seeing it at the airport while waiting to board the flight, which took off at 7:40 in the morning. So before any time, it's highly likely before anybody at the registry had seen that. And I think it would be really very reckless of the DFSA not to have travelled on the basis of that particular email, which had requested an adjournment from Miss Waterhouse, and that she was unable to attend due to ill health. There are lots of scenarios that may play out here, but if the court had refused that adjournment, as it did, it may have been that Miss Waterhouse was able to attend. She may have wanted it adjourned on the grounds of ill health. There are a number of things that could have transpired after that. So at that point, we had to assume it was still going ahead, and indeed, it did go ahead. But during the course of the day of the 9th of December, there was a very considerable number of exchanges between the parties. I recall receiving a telephone call on the plane from the registry, asking if we had seen the email and if the DFSA was going to respond. And we subsequently received an email at 9:09 in the morning, so mid-flight. That's at page 193. It begins at the bottom of page 193 and over the page at 194. The DFSA are requested to provide a response to the below request. And I responded at 12:30, again mid-flight, that we were currently preparing a response to the request, which we hope to provide in a few hours' time. And that response was then provided a couple of hours later, again mid-flight at 2:45. And in that we set out our grounds opposing the request for the adjournment hearing and pointing out the relevant authority for the court to take into consideration when determining that. On page 196, you'll see in that statement, I'm currently on a flight to the UK to attend the hearing arranged for tomorrow. I submit that it was entirely reasonable, in fact necessary to do that, given the significance and the importance of this matter for the DFSA. And then there's lots of correspondence, and I won't take you through all of it, but eventually it was decided at forgive me, at 9:13, 10 past 10 at night, and this is at page 205. Page 205, the registry confirmed that Sir Justice Sir Jeremy Cook directs that a hearing will proceed tomorrow and it will not order an adjournment on the basis of the medical certificate alone. Now, at that point, the DFSA had not seen any medical certificate from Miss Waterhouse. We understand that she had provided it to the registry with her email at 8:57 p.m. that you can see on pages 202 and 203. But Miss Waterhouse did not copy that to the DFSA, and we only saw that email, not the attached medical certificate, at 9:13 when it was forwarded by the Deputy Registrar, and Miss Waterhouse was reminded to keep the other side copied in on all correspondence. But the correspondence doesn't end there. It continues much later into the evening, on the 9th of December, Miss Waterhouse requesting reasons for the refusal of the adjournment. That's at page 206 of the bundle. She was told that written reasons could not be provided because it was not a formal application for the adjournment, application for adjournment, and the judge may be inclined to elaborate on why he's not granted the adjournment, and she was encouraged to attend. Then Miss Waterhouse sent a further email now in the very early hours of the morning on the 10th of December at 31 minutes past midnight at page 208. But unsurprisingly, the registry hadn't seen that at the time, so responded early in the morning at 9:22 on the 10th of December, saying that her correspondence will be sent to Justice Cook, but could not guarantee that he'll read it before the hearing, which was due to start at 10 a.m. Again, Miss Waterhouse. It was confirmed that the hearing will proceed that day. In fact, the hearing did go ahead, and as we've heard, it lasted for approximately 45 minutes. So as we can see from that rather long explanation, up until, at no point was it decided that the hearing would not go ahead until the actual hearing itself. And it was entirely reasonable for the DFSA to assume up until that stage that it was going ahead. And it was therefore necessary, given that the factors that I've highlighted, the importance of the matter, the very serious grounds of the accusations set out in the grounds of appeal challenging the FMT's decision, that it was only right that the DFSA attend that hearing and be properly represented. And indeed, during the course of the travelling to that hearing, a significant amount of work was required to deal with the late application that was received in the early hours of the morning on the 9th of December. I don't propose to go through the actual the medical certificate that was provided, as that was considered in great detail by the judge at the hearing, and his reasons for not accepting that as a basis for granting the adjournment requested by Ms Waterhouse are set out in the order with reasons. And again, the letter of the 27th of December 2019 it's not necessary for me to address that in any detail because that was not provided at the time. But in short, it was just too little, too late. And it may have been that if that had been provided before the judge had made his decision, that would not have altered the decision that he made. But taking that history of events into consideration, we would submit that those travel costs sought by the DFSA were entirely reasonable and proportionate and incurred necessarily the DFSA to attend the hearing on the 10th of December.
The amount for the travel cost, which was circa $5,000 US.
That's correct.
I suspect that's for a business class ticket.
That's correct. Yes, it is.
Okay.
So
that include accommodation costs as well?
It doesn't. No, actually. I mean, there were accommodation costs, but they were not included.
Okay.
They could have been included, but they have not been. I suspect it was because it was just overlooked at the time as being an additional expense that the DFSA incurred that's not included. But we could, if necessary, provide evidence of those costs. But we haven't sought them out, and we were not proposing to.
Okay.
But the business cost, the breakdown of the flight is set out at page 20. It's page 30 of the bundle, which is the local purchase order. And it shows there it was the cost of name of the employee as my name, the airfare, total charge for the airfare, class of travel, business class, and it gives the details there of the flight details. So flying out on the 9th of December at 7:40 in the morning. As I mentioned, Ms. Waterhouse's email was at 2:33 that morning. Then returning on the 11th of December at 1:35 in the afternoon. And the figure there is 18,845. Set out in the points of dispute, the DFSA's policy on international travel is that flights over 4 hours, employees are permitted to travel business class. Now in this particular case, it was indeed almost necessary. It would have simply been unworkable to be in economy class, given the events that unfolded and the work that was required in order to respond to the application that was received very early in that morning of the 9th of December.
Deputy Registrar, I'm sorry to interrupt, and I don't mean to stop Mr. Lake mid-flow. But I wondered whether we could take a short break. We've been going for close to 2 hours, and I'd like to request a 10-minute break if it's a convenient moment, or if not, soon as possible, please.
No problem. I'll just double check with Mr. Lake to make sure he's got no further submissions.
Sure. I just wanted to raise that.
Say staff costs, but I can return to that and deal with that very quickly after.
Okay. Shall we adjourn for 10 minutes and come back at 2:10, Miss Waterhouse? Does that suit? 2:10 Dubai time.
That's fine. I'm hoping that and thank you very much. I hope that we don't lose the connection. So I'm going to leave Skype open on my computer in the hope that we can just continue.
I think that's a good idea. Okay, we'll adjourn for 10 minutes and then we'll come back to the
Thank
start.
you very much.
Thank you.
Is it right if I remain in this room? Is that
Waterhouse, are you ready?
I'm here.
Yes. Okay, so Mr. Lake, the recording's on, isn't it?
Yeah.
Mr. Lake, I will let you continue on your submissions about the stuff.
Okay, thank you.
If you wish, yeah.
It shouldn't take very long at all. So I've dealt with the travel costs related to that is the work required by the DFSA in dealing with the application for permission to appeal. And in that regard, the DFSA is seeking $4,691 as set out in the statement of costs dated the 6th of January. Then since that date, there's been a further $2,448 in costs in preparing for this, the detailed cost assessment proceedings. And I'll split the two out. But in relation to the 4691, this represents DFSA staff hours that comprise 27 hours of my time at $153 an hour, and 16 hours by a paralegal at $35 an hour. And taking those two together, that comes to 4691. We would submit that work, that figure is really very, very modest indeed, and represents an entirely proportionate and reasonable amount of work that had to be undertaken to deal with Ms. Waterhouse's application for permission to appeal. Just dealing very briefly at a high level with that work, that included the correspondence with the court after the appeal was first filed at the end of August 2019, responding to Ms. Waterhouse's grounds of appeal and skeleton argument that was submitted on the 16th of September 2019. That's the DFSA's response was provided on the 7th of October 2019. Obviously, work was undertaken by me in relation to that, as well as counsel. We also undertook a significant amount of work, and this is paralegals' hours, understanding the documents that were filed on the 7th of November 2019. So I mentioned there were almost 700 pages, but we needed to understand those and put them into an order, which resulted in the index that we had compiled that is included in the bundle. So for that, we were seeking 16 hours at $35 an hour.
I just have a very quick question. I'm sorry to interrupt you. Are there any submissions or authority on the claiming back of costs for self-represented litigants?
Not that I'm aware of. I mean, this represents the hours that the DFSA had to invest. I mean, the use of the DFSA resources to defend itself in these proceedings. There was a cost to the DFSA, and that's as represented in the hours that we're seeking. Indeed, it's possible that the DFSA could have outsourced this to a law firm, in which case I don't think there would be any dispute as to whether those costs were somehow to be excluded. It represents dealing with that effectively in-house, which is a much more efficient and cost-effective way of doing so. I mean, the DFSA has a statutory objective to use its resources in the most efficient and economical way, and by keeping it in-house and dealing with it, that was the most appropriate way to deal with that.
Okay, rather than outsourcing the work.
Yes, that's right.
I get that. Okay. And again, going back to my initial question about the hourly rates, and you had mentioned that finance had kind of broken down the rates into
Yes.
the hourly rate of each person. Are these rates known throughout the organisation? I'm just trying to gauge a feel for how the DFSA operates in that regard, because if a law firm was to fight its own case, for example, then obviously the time attributed to that case would be broken down into the hourly rates of each practitioner, each fee earner, essentially.
Yes, right.
Do you have a similar model in the DFSA, or is there something that we can...
No, we don't. The way it's compiled, and understandably, our finance team are quite guarded over disclosing the individual worth or value or cost of a particular employee. So the figures that are calculated are based upon a banding for employees of a particular grade. So that represents the cost for me at my grade, $153 an hour. That represents the average banding for associate directors, broken down of all the benefits, the total value of the benefits broken down into an hourly amount, and the same exercise is undertaken for the paralegal as well.
Excellent. I mean, obviously we understand that you're someone who's quite senior within the DFSA. In terms of the paralegal rate, Mr. Lake, could you just run me through the amount again per hour?
$35.
$35.
$35
Okay.
per hour for the paralegal, and $153 per hour for associate director.
Okay.
And between that, there'll be various numbers that would represent an hourly cost for, say, managers of the DFSA or senior managers, and there'd be bands within which there'd be an average figure to represent their staff costs. So the work was undertaken in understanding the documents that Ms. Waterhouse filed on the 7th of November. As I mentioned, that work was largely undertaken by the paralegal, and resulted in the index that's included in the bundle, as I think I referred to earlier. Also, the DFSA had to update its response to Ms. Waterhouse's grounds appeal and scope argument, and we did that and submitted that on the 20th of November 2019. So that, again, was work by me in conjunction with counsel, and then further work in preparation for the hearing that went ahead on the 10th of December 2019. So the hours that are sought, it's 27 hours in total in relation to that work up until that point.
27 hours in total on this case full stop.
Sorry, let me check this statement of costs. Yeah, as I say, there's no accommodation costs sought. Let me just double check that. So, yeah, so if we go to page 21 of the bundle.
Yeah.
So there's 16 hours by me and Ms. Moyedin in relation to working on documents. 1 hour having attendance at hearing. That'll be the hearing on the 10th of December, and 10 hours travel and waiting time, which is again a sort of very modest amount of only 10 hours. Doesn't account for the return journey for the hearing. It was only sort of travelling to that hearing.
Okay. Thank you very much, Mr. Lake. Do you have any further solutions in that?
Not in that regard, no. That's the only aspect of DFSA costs are those that have been incurred subsequently.
So that concludes your two other categories.
That's
so you've
correct.
got 3 categories in total.
That's
Direct
right.
covered council costs, and now we'll hear from Ms. Waterhouse on travel costs, which essentially form part of a disbursement category, and then staff costs. Ms. Waterhouse?
Thank you, Deputy Registrar. With regard to, I'm hoping that I can cover first travel costs and then some other issues too. With respect, I'm sorry?
I said as you wish, so we'll be guided by you.
Thank you for that clarification, Deputy Registrar. Coming back to travel costs, I'd like to refer the court to point 4 of the points of dispute, and in particular the response of the DFSA on point 4. I say that Mr. Lake did not need to attend court in London to be able to give instructions to his legal team. I've said that he shouldn't have travelled at all, and one reason for that is that in this world of modern technology, telephones, computers, Skype, like we're using now, it's perfectly possible for a client to instruct their barrister in these circumstances, other than in person. In fact, Mr. Lake or the DFSA, I can't tell whom within the DFSA, appeared to have instructed counsel with regard to the hearing before the 10th of December. As far as I can determine, there were two occasions, and I'm referring to B27 of the DFSA's bundle, where there is an item within the Blackstone Chambers invoice relating to work which is stated to have been performed on the 8th and 9th of December, and the line item says that it was preparation for a hearing, advising in conference. The significance of that is, I say, that a barrister records items as in conference when they are meeting with their clients in conference, not work that they might conduct, for example, on their own, separate from their clients. And there are some other items there, settling response, submission to adjournment application and so forth, visible on the document. Further, within that same document, excuse me, 1 second. The invoice also reflects that some work appears to have been undertaken on the 26th of November, which again was ahead of the hearing on the 10th of December. My submission is that Mr. Lake could easily have instructed counsel by telephone on the hearing day as necessary, and it is open to counsel to seek a break within proceedings in order to take instructions. Further, in the matter of CFI 051 and 085, which is a distinct piece of litigation also before these courts, in which I was a participant, as was or is Mr. Lake, he will be aware that the data commissioner who was making submissions alongside myself as an interested party did not find it necessary to attend court and was able to instruct counsel effectively as needed by telephone. I was there when those instructions were being given, and I don't consider that the DFSA had any specific need to be there in person at the hearing in London, particularly in the context when they knew that there was at least a chance that the hearing wouldn't be going ahead, and knew that prior to the scheduled departure time of Mr. Lake's flight. With respect to point 11 of the DFSA's response to my points of dispute, I reiterate that Mr. Lake could easily have instructed counsel remotely. The DFSA say that it's a matter of internal policy that their staff are permitted to travel in business class. I think those were the words that Mr. Lake used earlier on today. However, there's no evidence before this court or served with respect to what the policy actually states. So I don't know, for example, nor does the court know whether permitted to travel in the context of the document means, for example, required to travel in business class. We simply don't know, and the court can't determine whether what Mr. Lake has described as the policy is in fact the policy, nor to assess whether the policy is reasonable or not, or whether the policy is subject to exceptions, or what guidance the particular employee within the DFSA must follow with regard to business versus economy. I say that the DFSA should not have travelled at all in the circumstances. They didn't need to. They could have performed that role by telephone on the day, particularly given the amount of work that we've heard gone into preparing the appeal and together with counsel. The application for adjournment was made before the scheduled departure time, so they knew. I say that a plaintiff in these circumstances, and by that I mean the DFSA, they're under a duty to mitigate their losses and to make reasonable use of the resources that are available to them. And I say that a reasonable use, if we accept, which I don't, that the DFSA had to be there, would have been to take into consideration whether there was a cheaper option available, which there was. And I've submitted that the costs of Mr. Lake's travel, if allowed at all, should be reduced to the cost of an economy class fare. I have included in my bundle at page 82 a quotation taken from the Emirates website with respect to not the date of Mr. Lake's travel last year, but to the date of travel for the same dates this year. The reason for that is that whilst I have checked with Emirates, they don't have data which reflects the historical costs of flights. However, they suggested that it would be appropriate in trying to estimate what these would have been to look at the same dates for this year. And so that's the purpose of the documents I've included at 82 in my bundle, which reflects that the lowest price for the particular flights in question would have been or would be 4,155 dirhams. Additionally, with regard to the travel costs, forgive me a second, I'm just trying to find a document reference. Yes. Additionally, with respect to travel costs, I don't consider that the DFSA have adduced any evidence of the actual cost that was paid to the travel agent. The document at B30 is entitled "Quotation come local purchase order," and it's unsigned. I don't see a receipt. So again, I highlight that as an example of the DFSA conducting these hearings on the basis of information which they assert is correct, but without supplying the evidence to demonstrate a particular assertion of fact. The onus is on the DFSA to justify each element. It is justifiable or proportionate, but I say that they have made, on this ground and in others, they haven't made an attempt to justify those costs. Rather, they've just stated what the costs are that they say were incurred. There's no evidence here with respect to travel costs that any analysis was performed to see, for example, whether that was the only way it could be done or whether it was the most cost-effective way that it could be done. And I should be grateful if the court doesn't lose sight of the overall context in which these events were happening. Thinking particularly of my status as I was in those proceedings, and am now a litigant in person with very limited resource, such that the DFSA must have known that if they were to at some point lose and seek these costs, the punitive effect on me as an individual in my particular circumstances, being unemployed, with various dependents, a sick husband, and so on and so forth, that the effect of me subsidising a business class fare to the DFSA in circumstances where I wasn't even given an opportunity to advance my most important grounds of appeal with respect to perversity and the weight of the evidence is more than harsh.
Does that conclude your Ms. Waterhouse?
No, I'm sorry. I've got a slightly crackly voice. I was just taking a sip of water. In my respect for this submission, I would say that it would be unconscionable for this for a person such as myself to have to pay these costs. And I would like to say a few words about Mr. Lake's submissions with regard to what he described as my conduct. He said, I believe, that I did too little, too late in terms of notifying the court of my ill health and inability to attend the hearing. In the circumstances that arose, it's unclear to me what I could have done sooner. I wasn't to know that on the 8th of December I would have an accident caused by ill health, of which there is uncontroverted medical evidence. There can be no penalty in terms of conduct for getting sick. And to Mr. Lake's points with regard to the 670 odd pages of documents that he said I produced in a disorganised manner to summarise his evidence, I say in response that the purpose of the hearing, as the correspondence reflects, and I source it on this basis, was to have an opportunity to take the court to those documents and to advance my submissions with respect to the significance of those documents, which weren't, as Mr. Lake put it, cherry-picked. He cannot know that because he doesn't know what I was going to say, and I guess he never will because I wasn't able to attend the hearing. The purpose of me requesting oral hearing was to be able to advance, as was my right, two very significant areas of my appeal with respect to the weight of the evidence and what I say were perverse findings of fact. And the significance of me being denied the opportunity for one reason or another to attend that hearing was disproportionately far more severe to me as an individual, because having been denied the opportunity to make an application before the FMT with respect to seeking permission to appeal, the hearing that should have taken place with me present on the 10th of December was the only opportunity that I would have had to advance my grounds, because I had before been refused, even though I hadn't made an application for the FMT. And given what's at stake, my livelihood, it couldn't have been more significant. There's no evidence that I deliberately chose not to attend the hearing. I couldn't. I was physically incapacitated, as the letter in the bundle, in my bundle, from Dr. Fraser subsequently produced to the court outlines.
But again, in the interest of time, I understand your submissions in respect of why the hearing, or in respect of why you wanted to adjourn the hearing. But the fact of the matter is it did proceed. So what I'm more interested in hearing from you is and you've discussed and provided your submissions in that regard already, in respect of the travel costs, but in respect of the staff costs, which I suspect is what you're talking about now, the proportionality and whether those were reasonably incurred. I can't change the decision that was made by Justice Cook on the costs order, and the question that's to be answered now, and I've heard Mr. Lake's submission on this, is whether the adjournment was ordered before he departed for the UK. And Mr. Lake's submission was that he was on the plane. In fact, I think he had arrived and landed when the court had ordered that the adjournment was not possible, absent medical evidence. In fact, really, the hearing was never adjourned. The hearing was vacated on the day and it proceeded. So let's perhaps stick, again, in the interest of time, to the proportionality and reasonableness, I can't pronounce that word sometimes, of the costs incurred by the DFSA on staffing and travel. And then we'll go and hear from Mr. Lake on the costs incurred in respect of these assessment proceedings now, which actually is the last category, and I forgot to mention that before.
That's correct.
Yeah. So, like I said, I completely hear you. We've seen the medical evidence. The case was vacated on the day. Justice Cook said on the day that he won't proceed to determine the matter at a hearing, and he will go off and do it on the papers. So let's focus on were they proportionate, the travel costs, if you've got any further submissions to make. And then on the staffing, were they proportionate and were they reasonable?
Thank you. At the end of there is time, I would like to make some general submissions. Mr. Lake has been given fairly ample opportunity to make his own submissions. But with regard to the internal costs of the DFSA preparation, if I may characterise it that way, which is dealt with by the parties at point 10 of the response, my submission is that the DFSA has adduced no evidence to demonstrate that the rates claimed, these are the rates that are set out at B19 for Mr. Lake's time and one of his colleagues' time, the paralegal. There's no evidence before this court that sets out with any transparency or at all how that internal costing mechanism actually works. We again only have Mr. Lake's word for it. What I would expect to see in a transparent court process is evidence that can be tested and challenged if it's appropriate to do so. So I make the point simply that the DFSA have again failed to discharge their burden and the onus, as they've not provided this court with any evidence to substantiate their assertion that this was the way that these things were normally calculated by their finance team. And I don't believe that document, although Mr. Lake can correct me if it's appropriate to do so, I don't believe that document's public or transparent. We don't have any evidence either as to what the work comprised of, because the document that the DFSA relies on doesn't break down those costs in terms of the work actually performed. So to Mr. Lake's point that work could have been outsourced, but it was cheaper to do it in-house. Well, we don't actually know that because we don't know what the work was. I don't see how that can be independently and objectively scrutinised.
Perhaps the question is this, Ms. Waterhouse: how long did you spend on these proceedings? Because that might be a good ballpark to kind of go through. I mean, the DFSA submitted that 27 hours were spent. Am I correct? Is it 27 hours?
Correct, yeah.
Like, yeah, between you and the paralegal
Correct.
together
That's
on the case, and I suppose it's evidence to an extent through the upload of the documents and the correspondences that you would have seen on the matter, the various emails exchanged by Mr. Lake and yourself, or Mr. Lake and the registry, or the paralegal and the index, for example, the index in preparing the documents which were uploaded by yourself on the system, as well as the hearing bundles. But do you have a kind of approximation of the time you've spent working on this matter? Because that might be something good to compare it to.
I don't. In terms, because I wasn't aware that was my obligation. I thought the obligation was the DFSA's to produce evidence of the basis on which they say the costs are reasonable. I would have to think back to the time and look at it in more detail. Because this as it has become clear from today's proceedings alone, there is a huge amount of history to the events leading up to the vacated hearing on the 10th of December. I don't want to provide information which is not wholly correct. That's my hesitation, no more.
Okay, understood. A good calculation would be this, and Mr. Lake did provide submissions on why the case was argued in the way it was, and that he provided submissions on conduct, and I've heard your submissions in response. Things were out of your control, but he's saying that perhaps because the case started in August, it ended in December, so at 27 hours, I mean, we've got to do the math. That's less than half an hour a week. No, it would be approximately an hour a week, I think. Between August and December, how many weeks is that from when the case was filed? So 26th of August?
Yeah.
Okay, so
4 weeks in September, October, November.
5 months, approximately 4.5 months.
Three and a half months.
3.5 months, okay. So that's approximately 14 weeks.
I'm sorry, I do apologise for interrupting, but just I would like to say that to that point, I think my submissions, if I was sufficiently clear, were twofold with respect to the FSA's officers' costs. One was that we don't have any independent verification of their assertion that the way that this is normally done is to take some sort of unpublished, non-public methodology applied by their finance department. We just don't know that is correct, or what the methodology is. And as to the hourly number of hours, well, we don't have a breakdown. But unless we understand what the methodology is and how it's applied in this case and in other cases, my submission would be it's not safe to simply take the DFSA's word for that's the way that it's usually done.
Okay. Mr. Lake, do you have any submissions on how the hourly rate was calculated?
It's set out in brief terms in the response to the points of dispute at page 19 of the bundle, that the rates claimed are based on the average hourly rate of total compensation paid to employees on a yearly basis at each of the grades, so the paralegal grade and the associate director grade. I don't have any information with me beyond that. Those figures were asked to be calculated by the finance team, and what the finance team could not provide to me was a specific cost per employee that would involve disclosure of an individual's salary and benefits and private information related to that. So the way it's based is on across that grade.
Okay.
For staff.
So it's perhaps somehow calculated based on the salary of the relevant person?
It's a number of factors. It would be the salary. It would be the salary, the cost of any other benefits, so providing health insurance, housing allowances, education allowances, all of that aggregated and then divided and broken down into an hourly rate. So what does it cost the DFSA on an hourly basis to employ a staff member at that grade? That is what those figures represent.
Okay. Ms. Waterhouse, do you have any further questions in that regard?
I suppose I remain. I thank Mr. Lake for his clarification. However, I remain sceptical because one assumes that if this is a established methodology that finance used to apply, there ought to be some sort of document which evidences that. So I'm thinking out loud, really, internal policy document within finance or similar. I remain of the view that the DFSA haven't evidenced that particular methodology. We just again have their word that that's the way things are done.
Okay.
The only other point I would make in that regard is that the figures sought are really very modest indeed when you compare them to the indicative hourly rates for legal practitioners in the GOFC. You'll see that the hours sought, the rates sought both for my work and that of Ms. Moyedin are merely a fraction of staff of much junior qualifications that the court would take into consideration as being a reasonable benchmark when assessing the proportionality and reasonableness of those costs.
And Mr. Lake, your title speaks for itself, but are you a lawyer?
I am. I'm a barrister. Yes.
You're a barrister.
That's
okay.
Correct, yes.
And may I ask when you were called?
I was called in 1999.
1999. So that would put you at probably if you were in private practice, perhaps a senior partner level. Again, just so we can compare it to the scale.
Yes, well, certainly. If you're looking at the registrar's direction, it may not necessarily be a partner, but it would be at the very least 10 plus years, and the indicatively hourly rate for that is $666 per hour.
Okay.
What we're seeking is 153, so less than a quarter of that.
And for the paralegal, please.
It's $35 an hour. So again, the paralegal is trainees up to 5 years.
Okay.
The rate for them is $479. The rate that we're seeking for the 16 hours of work, which we've conservatively given for the paralegal, the rate sought is $35 an hour. So again, it's less than a tenth of that for a trainee up to 5 years. So I don't think there can really be any suggestion that the rates claimed are unreasonable or disproportionate, and indeed the hours that we're seeking is based on a very conservative approach to those hours that are set out in the statement of costs. So 16 hours for Ms. Moyedin, that primarily concerned 2 days of work following the submission of the filing of Ms. Waterhouse's documents on the 7th of November. Ms. Moyedin spent a lot of time, 2 days, downloading those, analysing those, and putting them into an order and indexing them. So that's very easy to quantify those hours, the 16 hours. And the hours sought for me are 27 in total, which includes 10 for travelling. That's quite easy to quantify. 16 hours again, so 2 days work estimated over the duration of the case on documents, and 1 hour. Perhaps that should be reduced to 45 minutes, knowing how long the actual hearing lasted, but 1 hour for attendances at hearing, and that'd be in the hearing on the 10th of December.
And how much time would you say you spent on the plane doing work?
Well, the work was already underway at the time we received the email from the registry asking the DFSA for a response, and you can see that from the reply that I sent that we are already working on that. Forgive me, I can just find the relevant. So that email was received at, I think we were asked, at 9:09 in the morning. We were asked at 9:09 in the morning to provide a response to the below request, and I replied to that at 12:30. The DFSA is currently preparing a response to Ms Waterhouse's request, so work was already underway.
And no amounts were claimed for other members of your team? It was just the paralegal and yourself?
That's correct, yes. Although a colleague of mine was also assisting with this matter. So Mr Jensen,
yes.
In fact, submitted a document, and that's at page 198, the bundle. Because of the Wi-Fi signal on the plane, I recall I was having some difficulty attaching documents to the email. So the email that I sent referred to the decision of the Court of Appeal and GMC and Hyatt, but I was having some difficulty attaching that. So I asked my colleague, who was able to email, to deal with that, and Mr Jensen did that, and you can see that, page 198. So he did work on it, but we are not seeking any costs. We're unable to give a reasonable assessment of how much time that may have been, but it's an example of other costs that were incurred that we're not seeking.
Thank you. Ms Waterhouse, do you have anything further to add?
Just in terms of this particular area, to reiterate a point that I made within the points of dispute, which is further to note that as a barrister, Mr Lake could have represented the FSA. This goes to external counsel costs as opposed to travel costs, but that also needs to be taken into consideration with respect to counsel's costs, in my view. I should have dealt with that earlier on, but it reminded me to mention it when Mr Lake was asked about his year of call. So may I then move on to the other topics that I want to make submissions on, or how should we do this?
Go ahead. What's the estimated time, Ms Waterhouse, for your submissions, just so we can track time?
I think we had thought about a 4-hour time. So I'm going to try and do it within the time that this call is scheduled for, because I'm sure everybody wants to conclude today.
Oh no, it's so not about that. It's not about that. It's just so we can track the time internally for our purposes. Do you have an approximation of how long your submissions might take? Maybe 30 minutes. Okay.
Maybe a little bit longer. I prepared on the basis that I would do it all in one go. So I will attempt to do this in half an hour. Noting Mr Lake has had a fair amount of time. I think it's right himself. There are some general submissions that I'd like to make, and given the court's indication of what's an issue here today, I anticipate that you may say to me on some points that they are not matters for determination today. However, in very general terms, at broad brush levels, I would like to make a number of points. And it's then entirely a matter for the court whether and to what extent they have regard to those. Some of these are of a miscellaneous nature, but I would like to have them all recorded on the transcript. The first is my concern that the DFSA who are attending in person today, which I'm unable to do through reasons, again, of, not of my own making. My submission is that a party who is physically present at a hearing is at an advantage over somebody who is not. I made that, I queried yesterday with the court whether the DFSA were in fact allowed to attend in person on that basis, and in so doing, I referenced what was originally agreed with between the parties, or arranged really, when these proceedings were first scheduled before the situation with COVID-19 became a lot more serious and matters had to be adjourned. And the correspondence to which I refer, just bear with me a second, in terms of my submission to this court yesterday, was by email at 11:53, wherein I just pointed really to the court to what had been agreed between the parties back in March, when the DFSA accepted in an email on the 16th of March 2020 that the DFSA has no objection to a hearing held by way of video or telephone conference should the court decide that a hearing is required. It's a strange circumstance that in fact, each party, by that I mean myself and the DFSA, had said that they were didn't necessarily suggest that hearing was required. Both parties said that it could be dealt with on the papers. So to the extent that this court looks at any additional costs that the DFSA seeks within their assessments or their submissions, such as that approximately $4,000 that Mr. Lake spoke of, my submission is that the court should take into consideration the fact that the parties said they didn't need today's hearing, that they and that the court originally said on the 6th of April 2020 that the telephone detail cost assessment would be listed for a particular date. So there's 2 points in summary that I'm making. One is about, again, the unfair advantage that the DFSA have over me, and secondly about any costs that stem from this hearing today. And to the extent that the DFSA say that there is no unfair advantage, then my question to the DFSA is, well, why did it express a preference in later correspondence, later than that March-April correspondence, and much more recently, that it was its preference to attend today? If they didn't believe that there was an advantage to be obtained, why did it express such a preference? I make that as a rhetorical question. Additionally, I wish to put on the record that aside from the impossibility of travel at this time due to the COVID-19 pandemic and the particular vulnerability of my husband to that virus, the DFSA have not disputed the fact that were I able to travel to Dubai at all, my life and liberty would be at risk. In this regard, I invite the court to refer to the correspondence on the 15th and 16th of March 2020 between myself and Mr. Lake, which is to be found at pages 1 to 2 of my bundle, in which I stated I'm unable to attend a hearing in Dubai as that would place my life and liberty at risk. And Mr. Lake's response that, quote, the DFSA has no objection to a hearing held by way of video or telephone conference, should the court decide that a hearing is required. I also submit that costs don't always follow the event. I say that evidence of this, drawn from the correspondence between the parties and the Financial Markets Tribunal, is to be found at pages 7 to 9 of my bundle, where there is confirmation from the DFSA that they weren't seeking costs in the tribunal below, and confirmation from David Mackey, QC, President of the FMT, that I need not make any submissions with regard to costs. And Mr. Mackey says, in terms, you do not need to deal with costs given the position taken by the DFSA. I submit that the DFSA's approach to the cost in dispute today is inconsistent with its own approach in the same matter with the same party, and is unduly punitive. I consider that the approach that the DFSA has taken with respect to seeking aggressive costs with respect to the hearing was motivated in large part by my appearance in a television documentary which was aired by BBC Panorama, and you may have noticed that in the bundle I've included 2 articles, both published independently by the BBC News. The first article is at pages 18 to 24 of my bundle, and the second article immediately thereafter. I've included these articles so that the court understands the context and events which I submit led to the DFSA to seek cost in this matter. And the significance of the timeline is that the first article was published on the 28th of October 2019, and I understand that on that date alone it was read by over 750,000 people. Later on the 28th of October 2019, the documentary film referred to in those articles was broadcast. I understand that on that date alone, the film was watched by over 2 million viewers. Soon after that, the commission hearing went ahead in my absence, and the BBC published a further article, again within the bundle, the second of the 2 articles, entitled Deutsche Bank Whistleblower Hits Back at the Regulator. Well, that article's at me, and I consider the court should have close regard to the content of the article, but to make the short point, that these events aren't happening in a vacuum, if you will. I think that the DFSA were very upset with respect to me going public on television and in the press with regard to the suspicions of money laundering and Colotti, and that their aggressive pursuit of costs, which didn't evidence itself at no stage of proceedings, was motivated, at least in my respectful submission, by a desire to punish me and to punish me for speaking out. And the concern that I have is that I did nothing wrong with respect to speaking the truth. If it hadn't been true, it wouldn't have been published by the BBC. And that as a wider policy point, people think it's wrong and it's unfair. And indeed, within that second article, the BBC highlighted the unfairness of the commission hearing proceeding in my absence in circumstances where I had a valid medical certificate. I also submit that upholding the original cost order is likely to lead to further adverse publicity for the DFSA. That's my opinion, may or may not be true, but I think it follows there already having been adverse media you about it back in December of last year, and the further article, which is at pages 29 to 34 of the bundle, shows what another independent, or what sort of criticism my treatment has led to from independent journalists in the field. So, still on that theme, I consider that the propensity for additional media coverage is probably increased, and again, this is my opinion. But since that most those articles were published, Mr. Rehan, who appeared with me in the documentary, of course, has won his landmark case against Ernst & Young in the High Court in London. And of course, the Financial Action Task Force has published its findings concerning the need for the UAE to address some shortcomings with respect to anti-money laundering. My point is that it all remains very topical, and I don't believe for a minute that these events are not connected with respect to me speaking out on television and in the press. If I may move on to, I'm conscious, Deputy Registrar, of the guidance that you've given with respect to point one and points of dispute, which was my overall point, that the case shouldn't have gone ahead, and you said that that's not a matter that this court can determine. I don't question your judgment, but have a but I'm at least unclear that that's the case, because I would like to make some submissions about whether this should ever have happened in the first place. And in this regard, within their points of dispute.
Sorry, what was your query? Is your query whether the court or whether I have any authority to make or to overturn the cost order of Justice Cook? Because I confirm I do not. The cost order has already been made. But what, I'm not sure if I misunderstood you. I may have.
I may not have been clear, Deputy Registrar. I was attempting to make a submission which challenged that concept, and I was going to point to an aspect of Article 14 of the court law.
Of the DIFC court law. Is that in the bundle?
It's not in my bundle now.
Okay, just bear with me while I pull it up, please. Okay.
Apologies, I perhaps should have provided that. I refer to Rule 40.3 within Article 14.
.3. I've only got an Article 40, which is about the recovery of monies. I'm not sure if I've got the wrong.
I may have the wrong. I may have the wrong reference. But I'm looking at a passage. I'm having to work from my notes rather than. I'm sorry, I can't look at my computer to check that. But if I read to you the provision, maybe that will be the fastest way because I'm conscious of time. And the provision that that caused me to understand that those ground 1 points were an issue is that the registrar or judicial officer of the court, appointed for the purpose by the Chief Justice under Article 14 of the court law, referred to as an authorised court officer in this part, has all the powers of the court when making a detailed assessment, except the power to make wasted costs order or the power to make certain types of order with respect to misconduct. That's Rule 38.60 or Rule 40.12, which doesn't apply here because that relates to delays in commencing detailed cost assessment proceedings. So my understanding, and remember I am a litigant person, was that it was open to the court to look at the most important grounds. The court may not agree with that, but I make a further point by way of submission, if I may, which relates to the way that the DFSA have approached these proceedings. And that's twofold. The DFSA, within their points of dispute, have responded to the grounds that I raised within General Point 1, which is, if I can characterise it, the submission that it wasn't appropriate for the hearing to have gone ahead in the particular circumstances where I was physically unable to attend. And I think it's right to say that most of the documents within the DFSA's bundle, or at least a great many of them, before this court date, actually do relate to General Point 1. So I say that de facto General Point 1 is an issue. Furthermore, in my respectful submission, the court must also have close regard in hearing this matter to the overriding objective, and in particular to ensuring that the parties are on an equal footing so far as is practicable, and to the financial position of each party. And in truth, there is a huge disparity between the resources available to someone like me and to the DFSA.
Ms. Waterhouse?
Would you like me to continue? I didn't know whether you wanted to. I'm sorry?
Yes, I can make some comment in that regard. Mr. Lake, I mean, it's up to him to also make decisions if he wishes. But I hear you, and I hear your points about the overriding objective. But the fact of the matter is the DFSA is a regulator, and it's a very important one because it regulates financial entities within the GIFC. It is very difficult in my mind to reconcile that the DFSA shouldn't have argued or defended its case in the way that it did, only on the basis that you're a self-represented litigant. The DFSA reports to perhaps His Highness, I'm not sure who the DFSA reports to, perhaps
the President of the Centre.
The President of the Centre. It's got some pretty significant responsibilities, and it carries a reputation that it can't afford to taint in any way, shape or form. So it's as though, and a good analogy would be this, if you've got a company that is a very large one, and someone decided to bring action against that company, and the company is has to report to shareholders, and so on and so forth, you wouldn't expect the company to just defend that case on its own, only because there's a self-represented litigant. the company has to kind of do everything it can in its power to defend its case, regardless of whether or not there was merit to that case, because it can't afford, like I said, for damage to be sustained, reputationally or otherwise. So that's why I don't think it would be reasonable, like I said, for the DFSA to have completely carried on or not even defended its case or done not too much in terms of defending its case against the permission application. It did what it did, and it did so, in my view, reasonably. Again, we still need to break down the items, and that's why I'm very interested in hearing your submissions on the very specific categories that are yet outstanding, which is in respect of the staff costs and the travel costs. You've provided some submissions, but I'm still not sure how much of those amounts you're, not agreeing with. Again, usually in all cost assessment hearings, one side would say this is how much we're claiming, and the other side says we contest some of this amount. And it can't be all of that amount because a cost order was made against you, so you've got to pay something. But the amount that you don't want to pay, you've got to let us know why. My standing now on the starving costs, I mean, I've come to a decision because I hear everything you've said, but unfortunately I cannot take the points that you've made into account. I couldn't find the provision that you had pointed me to in the DIFC court law. I pulled up the court law and I searched for the word wasted, and I couldn't find it in the law. I then searched for the word registrar and kept looking, but I couldn't find the provision that you had read out to us now. So, but just my preliminary thoughts on what you said is that any time, I mean, I do have a very broad spectrum of power, whether in a cost assessment hearing or otherwise, very similar to judicial powers. Essentially, they are judicial powers. But at the end of the day, on the pecking ladder, the registrar is less superior than a judge. And I cannot overturn a decision of a judge in the court of first instance. It's not possible. And that's just a common sense approach, really. I can do so in certain circumstances for a small claims judge or for another registrar, but not for a court of first instance judge. So I do not accept those submissions, and the cost order is what it is. So the task before us now is for the outstanding amount, which is to the effect of, I think it's just over $10,000 US. We need to figure out how much will be awarded to the DFSA. We could sit here all afternoon and we could sit here until tomorrow morning and argue and throw those figures into shreds and figure out how and when they were accrued, but I don't think that would be a sensible exercise. I think a more sensible exercise is to find out from you exactly what proportion of those of those two figures you disagree with. You've said for the travel costs that you disagree with the business class fare, and that you, if I was to award costs for the travel expenses, it would be for an economy class ticket. And I've come to a decision in that regard, unless Mr. Lake or you have any further submissions to make. In respect of the travel costs, I've also come to a decision in that regard. Yes.
I'm very sorry to interrupt. Just to clarify, I think I made a further submission with regard to travel costs, which was that Mr. Lake shouldn't have travelled at all, and that he was able to instruct counsel remotely. So I think there are within that spectrum, there are three possible options. And sorry, just while you were speaking, I checked my bundle because I did have a distinct memory that I included some information from Part 40 of the court rules, and it is at pages that part of the court rules is within my bundle, including the text I referred you to. The text I referred you to is at page 10 of my bundle, the rest of the rules in that section then extend to page 17 in my bundle.
Miss Waterhouse, I don't actually have a copy of your bundle, funnily enough. I've had a look on the CMS and I couldn't.
It's the section.
I must say that I'm
okay. All right. Part 40 of the court rule.
I must say, if I may, Deputy Registrar, I'm very concerned that the court would conduct a hearing with so much at stake in terms of my livelihood without having at least my bundle before it.
I've got the index before me, Miss Waterhouse, but the bundle was not submitted on the e-bundle.
I'm guessing it's. I am deeply concerned by this because to the extent that I've been taking the court two documents, I'm not sure the court's been able to follow them without the documents themselves.
No, Miss Waterhouse. The bundle that I was referring to at all times when you were talking was the bundle that was uploaded on the e-registry, which is the DFSA's bundle. What always happens is parties agree a bundle and that gets uploaded. And if the parties don't agree a bundle, then the defendant has the option of then uploading their own bundle onto the e-registry platform. Okay, so
If I may, what I understand happened is that the DFSA uploaded its bundle via the e-bundling, e-registry.
e-bundling was what I was meant to say.
Miss Waterhouse, her bundle, I think, was provided to the court through a submission of documents through the e-registry system. So it's not uploaded to the e-bundle platform, but it is submitted to the registry.
Okay, can I have a look at that one?
So it is before the court.
And for the avoidance of doubt, Ms. Waterhouse, I have followed every single one of your submissions because there have been things that have overlapped with the DFSA's bundle, but you have only referred me to one document, being the one on page 10, and that was the one I couldn't find. But now I've got it before me, so bear with me while I pull it up. Part 40, yes. I've got that, and I've got a copy of the rules in front of me, which I've had at all times during the conduct of this hearing. Yes, please continue.
With regard to, I want to clarify because it sounded to me if you couldn't see or couldn't find part of my submissions, which then has evidence that the issue of the bundle. But my submission was going to be that there is no provision within Part 40 of the DFT court rules which limits, in my view, the jurisdiction of the court in the manner which has been asserted. That was my submission, and that was the reason that I wished to take the court to that part of my bundle.
Okay, can I just quickly read it? Just bear with me for 1 second. It's 40.3 and I'm reading authorised court officer.
Yeah.
So even if I have all of the powers of the court when making a detailed assessment, and look, I'm happy to hear more submissions from you on 40.3, but even if I had all the powers of the court when making a detailed assessment, I think I'd still need to see an application for permission appealing the decision of Jeremy Cook, and I don't think, I still don't believe I've got that power. I really don't. On the pecking ladder, he still will be, even though I would, for all intents and purposes, have all the powers of the court being all the powers of a judge, and I don't think that's what 40.3 means. I don't think I would, I really don't think I've got the authority to overturn a decision of a judge in the court of first instance. I think that section is referring to my powers in a detailed cost assessment hearing, which is to make certain orders within the realm of a cost assessment hearing only. and not outside of that. For example, I cannot make a order which is outside of what has already been claimed. And what's been claimed now is a sum of money from the DFSA on its costs in CFI 48. I can't, for example, now hear an injunction application from you in the proceedings because no such application was filed. Does that make sense?
Thank you for the explanation. The submissions I would like to make, maybe we can approach it this way in a kind of practical way, go to the fact that would be my submissions in relation to the case law, which I say was incorrectly applied on the 10th of December. It seems to me somewhat strange that as we're here today to discuss the costs that then were generated as a result of what I say was an incorrect application of the law to the facts of my case, and an incorrect determination of one authority that Mr. Lake has been allowed to refer to today, the case of Hyatt and the GMC. But if you tell me that there is simply no point or no scope for making those submissions, then I won't, in view of the concerns you've already made clear with regard to what is described as efficiency. I think justice requires it, but you may not agree with my submission.
You may obviously carry on, and you may voice what you wish to voice. Part of my role is to umpire the hearing today and to umpire the proceedings and to let you know what I have authority to do and what I don't have authority to do. And a big part of my role is to keep the parties on track. There are things that I cannot take into account. I understand that you have things you would like to voice, and I have patiently heard you voice those submissions, even though I cannot take them into account. I'm just trying to umpire the environment so that you're not wasting your time and this is not wasting your time.
Please don't understand that I'm attempting to be in any way critical of you. I'm talking about what I believe natural justice requires, and to that extent, if I were permitted, I would talk in brief detail about various cases, all of which are in my bundle. It seems unread by the court, with respect to four cases. However, if you're right, and I am willing to concede that you must be a better or you must have a lot more experience than I do in terms of the powers of the court and court officers for obvious reasons. There's no point in me making those submissions, which I've spent a very long time preparing, if they're going to be disregarded by the court, and I won't waste the court's time with them. So if you can just...
Miss Waterhouse, you need to understand, nothing will be disregarded by the court, but for the last few hours, there's been submissions that have been made that have not been relevant to the assessment proceedings today. Please make those submissions that you wish to make on 14.3. I'm happy to sit here and listen to them. And who knows, like you say, if there's something that is new to me, I will of course take it into account. But yes, I have run several of these hearings, and I am pretty well versed on what powers I have as a registrar. I will let you. I will let you.
Okay, let me try and do this in as quick a way as possible. I suppose my submission then is that even if this court has no power to set aside the order of of Justice Jeremy Cook with respect to cost, then I say that the court should find it within its inherent jurisdiction, and particularly with regard to the overriding objective, to at the very least reflect in its calculation downwards of the costs that the DFSA have been awarded, each amount to reflect the facts of this and circumstances of the vacated hearing on the 10th of December, namely that through no fault of my own, I was unable to attend that hearing. It was very much in my interest to attend, and I, like the DFSA, as they say, had spent some effort in preparing for that, but the consequences of that hearing far more significant for an individual like myself who now cannot work or care for their family than it ever could be for a financial services regulator. My submissions with regard to the law can perhaps be summarised relatively quickly, particularly if the court does, after the hearing, refer to the bundle that I provided and served. In that regard, at page 36 of my bundle, there is a case called Brabazon Drenning and the UKCC, and I wish to draw the court's attention to that in the context of that overall question about whether the hearing should have gone ahead or not, and in particular to the paragraph at page 36 from Brabazon Drenning that, and to quote, save in very exceptional circumstances where the public interest points strongly to the contrary, it must be wrong for a committee which has the livelihood and reputation of a professional individual in the palm of its hands to go on with the hearing where there is unchallenged medical evidence that the individual is simply not fit to withstand the rigours of disciplinary process. I submit that at the point in time when the CFI had to determine whether this hearing whether the hearing would proceed, this extract taken from another case exactly summarises the position I was in vis-a-vis the risk to my livelihood and reputation. As the FMT made an anticipatory refusal of my application, that I then went on to make or seek leave permission to appeal from the CFI. The CFI was in fact the only venue, having been denied that first opportunity, it was the only venue who could hear my submissions on the most important parts of my case. The DFSA didn't need to do all of that work internally to work out what they thought I was going to say in respect to those documents. That's the reason why I wanted to attend the hearing. There was plenty for me to say because there were well over 100 documents, as we've heard, for me to speak about. I was also a litigant in person. Sometimes what happens, reading through the case law in the area of medical adjournments requests on medical grounds, is that the court looks at whether there was another option. For example, if a party is represented by counsel, then the court might consider that it's appropriate to go ahead in the absence of the individual, because the lawyer can speak on their behalf. That wasn't an option in my case because, as we know, I was a litigant in person. There are cases that consider this in a little bit more detail. In particular, Fox and Graham Group PLC, which is at pages 74 to 81 of my bundle, where Mr. Neuberger set out a principle which I say applies at page 77. Of course.
Page 77 is what, sorry?
Of my bundle, which is within the Fox and Graham group. Have you found it? Are you clear?
Yes, I'm there.
Oh, thank you. So within that, I would refer the court to the principle set out by Justice Neuberger that it could be quite unjust for the court to dismiss an application for appeal which has a prospect of success, even if only a faint one, just because the applicant or appellant in person is apparently unable to attend, and because he's in person, no one is here to represent him. And he goes on to say that certainly where the litigant in person is seeking to adjourn for the first time, the court should, in my view, be very careful indeed about concluding that it would be appropriate to proceed with the application or appeal, notwithstanding the absence of the applicant or appellant. Those were the circumstances, I submit, in my case. The next authority is Decker and Hopcraft, which should appear in my bundle at pages 37 to 61.
I upload it. I'm not sure if this could have been done at the time, Mr. Waterhouse, but you may have been able to appeal Justice Cook's costs decision at the time, or 21 days after he released his decision. I'm not sure if you had made such an application then in respect of his costs order, but that would have been the appropriate forum for you to raise these submissions. But carry on, please. I've got Michael and Decker, Decker and Hopcraft before me now. Thank you.
Thank you. So just to take you to 3 paragraphs within that rather lengthy judgment, at page 43 of my bundle.
Yes, thank you.
And paragraph 26.
Thank you.
It states that in the context of what amounts to proper medical evidence, that was an issue before Justice Jeremy Cook. The point is made at paragraph 26, to summarise it for you, but I invite you to read it obviously for yourself, that it's not, whilst it's not necessarily important to note the person's inability to work in particular, and I refer to the fit note or sick note, which is in the DFSA's bundle in these proceedings, it is not necessarily an indication of his ability to attend court. Well, the DFSA will probably agree with that, but it's not determinative because, as the judge says, it may be, or it may also not be. And at paragraph 27, in summary, the judge looks at the possibility that it isn't necessarily a yes or no answer that a court faced with an adjournment application that has to make, so that, for example, a court may suggest accommodations that allow the participant to still engage, and you'll see that language there at 27, such that a similar approach may enable a litigant in poor health to participate adequately in civil litigation. Well, that's an opportunity I didn't have on that occasion. But I think most importantly at paragraph 30, the judge summarises a submission that was made in Decker and Hopcraft, which was that when considering an adjournment application, the court's approach should be to an extent affected by whether the matter involves applications of case management nature or final determinations on the merits. Well, in the context of my case and that vacated proceeding, it was the final determination. So it could not have been more serious. It was a determination on the merits, and it was a final determination. My submission is that at the very least, what the CFI should have done, if it did not consider my medical certificate, the one dated, I believe, 9th of December, so the one presented at the time or shortly before the 10th of December hearing, what it should have done was to have granted a short adjournment of time in which it could have told me what evidence it required if it didn't view that certificate to be adequate, and then have given me an opportunity to obtain it. Finally, in terms of the authorities, Mr. Lake spoke in brief terms and not in as part of the narrative about a case called the GMC and Hyatt, which was a more recent Court of Appeal case. And that's a case, as I understand it, that the DFSA relied on. We've heard Mr. Lake mention that his colleague, Mr. Jensen, took some time to email a copy of the authority to the court. With respect to GMC and Hyatt, I say that my circumstances and the basis on which this whole dispute arises can easily be distinguished from the authorities, this authority, that is to say the GMC and Hyatt, on the basis that the judge in that case, and the material I'm now referring to is at pages 62 to 73 of my bundle.
Yes, thank you.
And my apologies, I was unable to obtain the original law report. So this is, in fact, just to be clear, a summary that's been prepared by lawyers of that decision. However, it does include the language of the judgment. Just to summarise what happened in that case, Dr. Hyatt, a medical doctor, relied on a sick note which is similar in the form, not the content, to the one that I put before the CFI in support of his application for adjournment on the basis of ill health. It was also a case of professional discipline, but I imagine that as a doctor, Dr. Hyatt was better positioned than a legal professional like myself to determine how comprehensive a sick note is as medical evidence. Now, in that case, the Court of Appeal did find that the sick note in of itself was insufficient. But the reason that I say it can be distinguished from my own case is to be found at page 72 of my bundle, which is within that document. And it's paragraph 54 within that law firm briefing on page 72, where the judge explains that it was one of the most striking features of this case that Dr. Hyatt had identified no medical evidence that postdates a sick note of 7th of November 2016, that at no stage did he suggest that if the tribunal had undertaken its own inquiries, they would have discovered additional medical evidence that would have demonstrated to them that it was inappropriate to continue his absence. He's not done that, choosing instead to stand all for on the terms of the sick note alone. The significance, I say, of this is that in my case, I did take steps that, and I did obtain the letter of Dr. Fraser, which proves that it was a genuine medical complaint. But it seems that for whatever reason, and I hear it now as a procedural one, is the court can't consider the context of the overall environment in which the costs were generated, which I submit as unsatisfactory.
Thank you. As I said, the forum for you to raise those submissions would have been at probably a permission hearing, appealing the costs order of Justice Cook, but no such application was filed. And I'm still of the view that Article 40.3 of the RDC does not give me the power to vary the order made by him. So thank you for those submissions, but I'm not satisfied that 43 extends to, like I said, a power to overturn a decision of a court of first instance judge.
Thank you for hearing me, and thank you. I think I also made a submission that even if today there is no power to overturn the order,
Inherent jurisdiction,
which I say was incorrectly made, then the submission that I also made was that in those circumstances, should the overall circumstances of the case surely gives the court discretion to reflect the circumstances of the case in the amount that it adjusts those amounts by. So, for example, earlier today, there was a 10% reduction in council's fees. I think that's right. What I'm saying, perhaps not articulately enough, but to be clear, what I'm saying is that the overall injustice to the situation can surely be taken into account by the cost officer in determining what proportion of the cost can be not overturned but reduced by.
Yes, and that's having regard to the script of the RDC on proportionality. I cannot take proportionality into account by having regard to your situation. I can take proportionality into account by having regard to the DFSA situation and the case at hand. I do have thoughts, like I said, about the travel costs and the staffing costs. So if that concludes your submissions in respect of those two categories, then I'll hand down my decision in respect of travel costs first and then staffing costs second. And then very finally, I'll hear very brief submissions, we're very pressed on time now, on the cost of the detailed assessment today. And I've also heard your submissions, Ms. Waterhouse, on the fact that the parties had originally agreed that the hearing was to be conducted on the papers. So what I'd be keen to hear, Mr. Lake, on is how much time he's attributed to those costs that he will be claiming for the assessment hearing, for attending the hearing versus the cost of preparing the relevant documents. So can I hand down my decision on travel costs first, or do you have further submissions to make, Ms. Waterhouse?
I don't believe I have any further submissions. Thank you.
Mr. Lake, yes.
I have the opportunity to reply.
Of course you can.
Okay, thank you. Dealing briefly and hopefully succinctly once and for all with this question of the court's power, I think the relevant rule is in 38.22 of the court rules regarding the power here to determine the order or overturn the order that was made by Justice Sir Jeremy Cook, that there would be, the DFSA would be awarded its costs subject to this assessment. And 38.22 provides, in relation to making an order of costs, 38.22 in particular, the court must give effect to any orders which have already been made. So we would say there is no scope to go back and second guess an order which has already been made by a judge. The purpose is to give effect to that order in these proceedings by carrying out a detailed assessment of costs that were, whether they were reasonably and proportionately incurred and whether they are reasonable and proportionate in amount. And you've heard my submissions on that basis that we submit. They are. So hopefully that addresses the issue. Miss Waterhouse also made the point that she said whether this question over whether the order as to cost should ever have been made has been put in issue by the DFSA, that's not quite right. We included the relevant material within the bundle leading up to the hearing on the 10th of December to demonstrate the conduct of Miss Waterhouse that is relevant and clearly relevant within the parameters of the rules in 38 and 40 as to determining the proportionality and reasonableness of the cost that we're seeking. So that's why the material's in the bundle. It's not because we're seeking to vary or change that order of Justice Cook. Now, as to costs, Ms Waterhouse made the point that the DFSA has aggressively pursued its costs against her, and she made various references to BBC articles. Things. The DFSA's position is that those BBC articles were misleading. They omitted a number of important facts. For example, the actual findings that had been made against her in August 2019. They came well after the event and made no reference to those findings having already been made. But that is water that's already flowed under the bridge, and I don't propose to reopen that now. But certainly the DFSA has not aggressively pursued its costs against Ms Waterhouse, and I've checked our skeleton argument and indeed our submissions in response to Ms Waterhouse's grounds of appeal, and I can find no reference to the DFSA seeking its costs or applying for its costs against her. She terms as aggressively pursuing that. That was not the case at all. Rather, the cost order was made by Justice Sir Jeremy Cook within his own discretion, as is permitted within the rules, on the basis of the conduct that he had seen leading up to the application for permission to appeal and Ms Waterhouse's non-attendance on the 10th of December 2019. Ms Waterhouse has also referred to various authorities, authorities which predate the GMC and Hyatt case, which was a decision of the Court of Appeal. So those authorities were taken into consideration in the Court of Appeal's decision in GMC and Hyatt, so that authority would be superior to those. But some of them they're very different in certain respects. Ms Waterhouse referred to the Bravers and Drenning decision in her bundle. And there's a quote, an extract, a passage of page 36 of her bundle, which refers to unchallenged. It says it must be wrong for a committee which has the livelihood and reputation to go on with a hearing where there is unchallenged medical evidence that the individual is simply not fit to withstand the rigours of the disciplinary process. Now, obviously, that decision was considered in the GMC and Hyatt case, but there are a number of aspects of that quote which are relevant to take into consideration. In this particular case, the judge didn't go on with the hearing. He dealt only with the question of whether or not it should be deal with the adjournment, and he quite clearly concluded that it would have been unfair for the DFSA to address him on the merits of her application for permission to appeal in Miss Waterhouse's absence. So what he decided was not to go on with the hearing, and in fact to adjourn it and deal with it on the papers. And again, that's relevant to the decision that Miss Waterhouse referred to at page 77 bundle, which I think is the Fox and Graham decision, or is it? Sorry, yes, it's the Fox and Graham decision there. So on the passage Ms Waterhouse referred to said it would be quite unjust for the court to dismiss an application or appeal which has a prospect of success, even if only a faint one, just because the applicant or appellant is in person, is apparently unable to attend, and because he's in person, no one is here to represent him. But the question before the court on the 10th of December was whether or not to proceed to deal with it in Miss Waterhouse's absence. She didn't turn up, and the court decided not to proceed to deal with it in her absence. Rather, the court decided to proceed to deal with it on the papers. Miss Waterhouse also referred to pages 67 and 68 and the commentary on the GMC and Hyatt case. Sorry, not pages. Referred to the commentary, but in that, at pages 67 and 68, it's quite clear at the bottom of page 67, going over to 68, the court has repeatedly said that a pro forma sick note of the kind provided here may well be insufficient to justify non-attendance at a hearing, particularly if it refers only to unfitness to attend work. The fact that a person is certified on medical grounds is not fit to attend work does not automatically entail that person is not fit to attend a tribunal hearing. Though very often that would also be the advice of the medical practitioner. And what Miss Waterhouse provided, and which was taken into consideration with great care and in great detail by Justice Kirk, was simply that, a sick note that gave no evidence whatsoever of her ability to attend a hearing. It only signed her off work for statutory sick pay purposes. Now that's precisely the issue that these authorities dealt with, and the GMC and Hyatt gave much greater clarity and guidance on the relevant issues that the court should take into consideration, and which, with greatest respect, Justice Cook did take into consideration in reaching a properly considered view and conclusion on this, as he did. There was one other brief point that I wanted to return to, which concerned whether or not this hearing should be held, and the unfair advantage that Ms Waterhouse refers to. Now, under the rules, 40.29, where a party files points of dispute, the party must file a request for a detailed assessment hearing. So as I've said, the DFSA did not apply to the CFI in dismissing her application for permission to bill for its costs. Rather, they were rewarded by Justice Sir Jeremy Cook based on his assessment of the circumstances at the time. But then where those costs were not agreed, as they are in this matter, DFSA is required to file a request for a detailed assessment hearing. That is why we're having a hearing now. So it's not an aggressive pursuit by the DFSA at all, nor would the DFSA say that Ms Waterhouse is at any unfair advantage. We've seen clearly from this afternoon that she's able to participate fully remotely. It just happens to be practically more convenient for the DFSA to attend in person, as I'm sure Ms Waterhouse would do if she were able to. So there simply cannot be any suggestion that the DFSA has an advantage by being here in person when Ms Waterhouse has very eloquently and very professionally delivered her submissions over the telephone conference this afternoon. And lastly, in relation to the costs of the business class travel that Ms Waterhouse has referred to, she said there's no evidence of that, there's only a local purchase order. If required, I'm sure it is possible to go and obtain further detailed evidence of the actual cost that was incurred, but that was included to demonstrate that on the 28th of November, that ticket was booked by the DFSA with its travel agent, Sheriff Travel. So 28th of December being just 2 days after the hearing was ordered to be held on 26th of November, that was the price provided by Sheriff Travel with the specific details of the flights that I did in fact take. And those figures are, the 18845 is very similar indeed to the figures that Miss Waterhouse has provided in her quote at page 83, the cost of the business class travel. The figures there are 18,335, and we are seeking 18,845 for the business class travel. And as I've already submitted, it was indeed absolutely necessary to be able to work on that flight. It was taken just a day before the hearing to have endured economy class travel. And to continue to work on that flight would have not been practicable, and returned to Dubai as soon as reasonably possible after the hearing on the 10th of December. It couldn't have been booked earlier because we didn't know what time the hearing was going to finish on the 10th of December. It may have gone all day. So I left very early on the early afternoon on the 11th of December. I think they're the main issues I wanted to say by way of reply to.
Thank you. Right. So, with regard to travel costs, the court does not usually indulge business class travel. I am satisfied, however, that the DFSA was reasonable in requiring a member of its legal team to travel across to the UK for the hearing. But given that in this day and age, business class travel is more of a luxury than a necessity, I am inclined to award the price of only an economy class ticket, Mr. Lake. Based on the document provided by Ms. Waterhouse at at her bundle, or in her submission on the 21st of June, I know that there was an Emirates airline quotation, and I believe the amount was for 4,155. I think that is a reasonable amount, and for that reason, I will award the price of an economy class ticket rather than a business class ticket. I'm not sure how much that translates to in US dollars, but we can, once we produce the order, calculate the maths for it. But as we know, the dollar is hedged, the dirham is hedged on the dollar, so it won't be a matter of what the exchange rate was at the time.
I think it's $1,130 based on exchange rate 3.675.
Okay, $1,130. 0.675, sorry?
Yes.
Okay.
The exchange rate 3.6.
Okay, excellent. So I will award $1,130, 0.675. I will also award the full extent of the staff costs claimed by the DFSA. I have heard both parties' submissions in that regard, and I'm pretty satisfied that 27 hours at a total of, and I'll just come to that figure in a second. Mr. Lake, you might be able to remind me, please, what that figure was.
It's 27 hours at $153.
For yourself, yes, and the amount claimed by the paralegal.
And then 16 hours at $35.
And what was the total amount for both of those? Total amount of staff costs, sorry.
Total amount is...
Was it 4,681?
Sorry, give me. It's 4691. That's right.
$4,691.
Dollars, yeah.
Right, so I award $4,691 for the DFSA's own costs of running these proceedings. I'm satisfied that had the DFSA not taken those expenses on themselves, that they probably would have allocated the work to a law firm, and the amount would have been much higher, particularly with reference to the Registrar's Direction Number 1 of 2017. I did note Mr. Lake's submissions about the hourly rates for someone who is 10 plus years qualified, or a trainee solicitor who is under 5 years qualified. And I think we can both agree, as in Ms. Waterhouse, you can probably agree that the amounts are very negligible compared to what someone of Mr. Lake's experience would be claiming otherwise. So 4691 is awarded in full. This now brings us to the cost of the detailed assessment proceedings. Now, we have been in the hearing for 4 hours. Mr. Lake, from the $2,448, how much of that time is attributed to attending the hearing today? I did think that there was good reason for us to have a hearing on the basis that the submissions made by the DFSA, as well as the points of dispute submitted by Ms. Waterhouse, weren't in the usual form I would expect from parties when I come to make decisions on what costs should be awarded. So I did think it was very necessary to have this hearing, and lo and behold, we have been here for 4 hours. So even if the reason I'm asking Mr. Lake is whether any time has been attributed is because, in fact, I will give him an opportunity to claim his costs of attending today's hearing to the extent that amount 2448 does not factor in the 4-hour hearing today. And if it does factor in hearing time, how long? And then we can just add the other hours on top of.
Okay.
If you've got submissions to make, obviously. So I'll hear from you. Ms. Waterhouse can obviously respond, and then I'll give you my assessment for that final category.
Okay, thank you. In short, the 2448 does not include any hours allocated for today. We didn't know how long the hearing would go for. So the 16 hours there is based upon the work that was undertaken in relation to basically two days of work that has been undertaken since the 6th of January 2020 in preparing for these cost assessment hearings. So that date being significant, being the date on which we provided our statement of costs at that time to Ms. Waterhouse. And since that date, there's been a very considerable amount of work, which we conservatively provide a figure of 16 hours for, at $153 in relation to preparing for these hearings. Now I can go through what that work consists of if it were to sit.
I think it's self-explanatory based on what has been submitted in the bundle that's been uploaded. I'm interested to know whether council costs are being claimed within that amount, or whether it's just the in-house costs of the DFSA's.
Sorry, yes, that's right. Yeah, so this, the 2668, there were in fact, that's two figures, 2448, which is 16 hours, representing my time in preparing for the detailed cost assessment proceedings, as well as an additional $847 in council's fees, £675 for work that Mr. George did when assisting with the response to the points of dispute. And the document, the fee note demonstrating that, is at page 235 of the DFSA's bundle, and that shows entries by Mr. George on the 27th of February and the 6th of March 2020 in relation to Ms. Waterhouse's points of dispute that we've discussed in these proceedings. So that's an additional $847 for Mr. George's fees, and then 16 hours at $153 an hour to 2448 my time in preparing for these proceedings, plus the 4 hours of this afternoon.
I'm not quite sold on council's fees because I think that this exercise, and given the amount that's been claimed by the DFSA, circa $40,000 didn't necessarily require any input from council. So I won't be awarding council rates, but Ms. Waterhouse, happy to hear from you on the DFSA's costs of the detailed assessment proceedings, if you wish to make any submissions before I make up or hand down my award in that regard.
Thank you for giving me the opportunity. I was going to make the point which I think you just made, which is that in my submission I don't believe that it was remotely necessary for the DFSA to instruct Queen's Counsel to respond to these points of dispute, particularly in circumstances where Mr. Lake, through his involvement, seems well apprised of all of the events in question. But I would reiterate my concern, which is that notwithstanding the fact that the onus and burden is on the DFSA to demonstrate that their costs were reasonable and proportionate, they didn't produce any evidence to explain what work was done, for example, in preparation for today's hearing. But more importantly, and you've explained the reasons why you thought a hearing was necessary in the circumstances, but I think that the court should have regard to the DFSA's position from March this year, so after the January submission that Mr. Lake referred to, but from March until now, I find it difficult to believe that amount of work had to be carried out. But it's unclear to me what work was carried out. And I think that when the court looks at this figure, it should at the very least reflect downwards the amount to reflect the fact that each party were content to proceed without a hearing. That would have been a step that each party was willing to take in order to reduce the overall cost burden. So I make that as a general point.
Thanks, Ms. Waterhouse. Having looked at the DFSA submissions, and I can walk you through those on the CMS, but there was various submissions that they made from the date of filing the notice of commencement of assessment to the date of this hearing today. Now, I can't see, Mr. Lake, please correct me if I'm wrong, but I can't see on the system submissions which were made at the time of filing the bill of costs. Any substantive submissions in that regard. I can see the pro forma forms that were filed, and I also note your reply to the points of dispute, and that looked like a pretty detailed response to that, but I can't see a formal submission filed. I can also see Blackstone Chambers' invoice, or its fee note, as you say. So I do hear Ms. Waterhouse on that point, and I think that 16 hours between uploading the e-bundle and responding to correspondences is probably a little bit too much when taking into account the work that's been completed. So I will I will give you the the 540 for today's hearing, being $135 an hour for 4 hours.
So $153.
$153, I'm sorry, 153 times 4, so that's $612 to attend today's hearing.
So if I may, I think the work undertaken, so the notice of commencement of assessment of bill of costs was filed on the 4th of February.
It was filed on the 3rd, yes.
3rd of February.
Yes, on the 3rd.
Then after that,
I believe Ms. Waterhouse filed her points of dispute.
she filed her points of dispute on the 24th of February.
And then you responded on the 8th of March.
That's the 7th of March, I think. Yes, that's right. Yes. So the 16 hours represents the work. Some of the work taken in relation to that, as well as the preparation for this hearing.
Okay. Okay. I suppose when you factor in the preparation for this hearing and preparing submissions, that is, yeah, I mean, 16 hours. Let's have a look.
So 16 hours in working on the points of dispute. So
yeah.
As
Look,
well
I
as...
actually do think that's reasonable, Ms. Waterhouse, taking into account the time obviously prepared, or the time it took Mr. Lake to prepare for the hearing. I'm sure you've spent a fair bit of time also getting them together. I don't think actually it's unreasonable, the 16 hours. So I will award the full amount of, where are we? 2,448.
But just to be clear, you'll exclude council's fee, the invoice at page 235 of the DFSA's bundle. Is that correct?
Correct. So I'm excluding $847 in council fees. I don't think that is reasonably incurred.
Thank you.
So to round up, we've got $2,448 plus 612 attending today's hearing, plus the economy class ticket on Emirates being $1,130.675. plus the staff costs, DFSA staff costs of 4691. And then the disbursements being council's fees, 28,350. Which means that the DFSA to be paid $37,231 and 67 cents in US dollars. Ms. Waterhouse, usually we would require payment within 14 days, but I will give you a bit more time. I'll give you 21 days.
Thank you. Will there be a judgment, so to speak, or a document generated as a result of today's hearing?
Usually it will be an order, not a judgment, on the basis that we've had the hearing and I've given you my reasons throughout as discussed. So I won't provide reasons, but it will be an order setting out what is to be paid. It would be a very short order confirming the 37231.675 and the registry can provide you a recording of this hearing if you wish to listen to the reasons again.
It may be helpful, so that would be appreciated. Given that it's a Skype recording, as I understand it, is it possible for you to direct that no charge would be made for me obtaining a copy of the transcript, please?
It won't be the transcript. I would definitely direct that no charge will be for the recording. There is a charge for the recording, so I will make sure that the registry sends that to you free of charge. But the transcript, I do understand that there is an associated fee for that.
A recording will suffice, I believe, so thank you.
No problem at all, Ms. Waterhouse. Okay, thank you very much for your time.
So, thank you.
That concludes the cost assessment for CFI 048. Thank you.
Thank you.
Thank you.
Do you, thank you, Registrar. Are you doing many hearings by?
Lots of hearings are taking place